Lord, under compulsion, Lord, I'm mentioning item number 273 of your Lordship's list.
Yes.
Now, Lord, this is in relation to an application order, Order 7, Rule 11, which has been rejected by the trial court below. Now, my Lord, the next date which is there fixed in the trial court is today, and it is for argument. My Lord, this application which is filed before your Lordship will become
Argument of the
entire suit. My Lord, will kindly, my Lord, takes it on day after tomorrow.
it is not urgent. Yes.
Yes.
My lord, may I have
Please
permission?
indicate the urgency in the
Lord,
list.
I have-
Hand over. Please hand over the slips indicating the urgency.
Your lordship for taking a leave for filing. Urgency is the same for the argument stage and order.
File it. No leave is necessary. File it. It will appear.
My lord, I have permitted to mention, my lord, 124
My lord, it was mentioned yesterday by my lord, and that was allowed by your lordship, but today not listed, my lord.
When
Very
the files
urgent.
come, I told all of you
My
that
lord,
the files,
tomorrow,
all
my
the
lord,
files
sit
are.
for argument, my lord, last
Maybe.
time. My lord,
Tomorrow is the argument.
argument, my lord.
Argument of
Argument of the matrimonial suit, my lord.
what is the impugned order?
Impugn order, my lord, the order 18, rule 17. That was not allowed by the court below, and that is the impugn order. Very urgent, my lord, my lord. I have annexed the order last yesterday.
আসেনি কেন কালকে
I have annexed the order.
এটা কালকে দিয়ে দেবেন
Yes, my lord.
One shall have disposal, 1931 suit for party. Change from 1932.
it is appearing in the list.
Put Parallel Justice,
Let the files come. Please wait here with the court for this week. Yes.
My lord, I have one urgent unlisted matter, my lord, 227 application. My urgency is, my lord, the learned civil judge, having jurisdiction of building tribunal, has vacated my stay, and resulting thereto, the concerned municipality is going to demolish my building within 2 days. But my lord,
is appearing for
kept
the
the original
Which municipality? Who is appearing for the municipality?
Pandiati municipality.
Who appears for Pandiati municipality?
I will serve, my lord.
File it. Serve.
Lordship, may I have
Yes, sir, I will, but should I hand over the number to your lordship's court officer, my lord, after filing?
After filing, hand over the number.
My lord, deeply grateful, lordship.
to mention a matter for inclusion, my lord. This is a civil divisional application. And I am aggrieved by
For inclusion, please mention the urgency in the slip. Hand over the slip.
My
the
lord,
only situation is that, Lord, the school Julian Day has been
Please mention the urgency in the slip.
Yes,
Hand
Lord,
over
yes,
the
Lord.
slip. Without the
certified copy.
why?
We are facing an order of demolition to be executed tomorrow, by virtue of an NGT order. What the issue is?
Have you annexed the server copy of the order?
Yes.
Need to file without the certified copy, but with the server copy. And you have to also annex the copy of the application that you have applied for the certified copy. That also has to be.
One thing cannot be HGT, although the rule 28 permits for a non-party to the suit. But difficulty is I am not a party to that HGT order. But I am a necessary party. Without me, my building, my residential house is being demolished.
All right.
I have your lordship's kindly to mention one matter for upgradation, your lordship. The urgency is
Please, I have told all of you, please mention the urgency. Hand over the slip.
My lord,
Because
my lord,
executed.
File it.
my lord,
Tomorrow it will appear.
under compelling circumstances, my lord, I am mentioning one item number 135 of today's list. Matter is likely to be taken up, my lord, date has been fixed by the Howrah court tomorrow, my lord. So, my lord, he will also take some matter tomorrow, my lord.
It will
135, my lord.
happen in a day.
Urgency, my lord, very urgent matter, my lord.
What is the date fixed for in the court below?
My lord, otherwise the application will be
The date fixed for what?
date fixed for final hearing of section 25. Section 25.
Nothing will happen in one.
My lord,
My lord,
may I be permitted to mention this, my lord? This matter is fixed on 21st before the lower court, my lord.
For what?
My lord, for further cross-examination, what is happening, my lord? My lord, a commissioner report has
Please
been
mention
admitted.
the urgency in the slip. Hand over the slip.
Milord, all the matters, sir.
Mention the urgency in the slip. Hand over the slip.
One thing, my lord. My lord, this my lord, impugned order was passed on my lord 10th February. On 14th February, my lord, I filed the divisional application. 17th February, my lord, yesterday was the date fixed for argument. My lord, now my lord, next date has been fixed for court today.
Next date has been fixed on.
For 18th, just on the next day.
So what can be done?
मतलब anyhow, मतलब my application, मतलब this division has kindly text it, मतलब
What is the item number?
it was filed on last Friday,
Last Friday.
last Friday,
What,
14,
what was the date you have mentioned in the presentation form?
well, 19th, मतलब.
So
So, मतलब let it appear, मतलब, but
it will appear on 19th.
मतलब
Have you seen the list? In all the matters where the presentation date is today, all the matters are appearing. Tomorrow's date, it will appear. If it does not appear, mention before the
Lord,
court.
since the matter has been fixed today, my lord,
Mr. Haldar, I assure you that the matters will be listed on the date you have mentioned in the presentation form.
Lord,
That much I can assure. So if you want to prepone from the date mentioned in the presentation form,
well,
that cannot be done.
I'm taking up this matter on 19th. Just tomorrow, my lord.
So tomorrow it will appear. Why are you anticipating that it will not appear tomorrow?
Milord, Milord, may I mention the expeditious hearing of the senior
No urgency.
Your
Yes,
Lordship,
senior citizen matter?
maybe.
Milord,
No
pending
urgency.
for 12 years, 13 years.
Have you seen the latest judgment of the Honorable Supreme Court on expeditious hearing? Honorable Supreme Court is deprecating. Don't pass orders for expeditious hearing. Bring that judgment when you will move this application.
Milord, let it be. Let it be.
Have you gone through that judgment? Go through that judgment and come bring a copy of that judgment when you will be moving
Another
that
is the
application.
execution matter, Milord. Another is the execution matter. It will the said house will
What is
be
the date fixed in the execution?
on 28th, Milord.
On 28th, mentioned in the next week.
Your Lordship, may I have Your Lordship's kind leave to mention a section 24 application, Your Lordship.
Section 24,
Your Lordship.
first time or hearing?
Your Lordship, first time, it's a motion.
First time it has not appeared or it is appearing in the list.
Your Lordship, it is probably not appearing in the list, Your Lordship.
Hand over the slip.
Lordship, for
Obliged, Your Lordship.
expeditious disposal, suited is pending.
No urgency, yes.
Extreme apology, but I'm lot of body, but I'm break, but I can move it. I'm dwelling, but I'm residing in that place. Kindly, but
Why you waited for so long?
this was served at a different site.
When did notice was served? When notice was served?
Served on Saturday. This Saturday.
Saturday. So you had yesterday, you did not come. Tomorrow it will appear. No.
Expeditious.
May I,
I'll give the number thereafter I will see.
may I have Lordship's kind leave to mention item number 138 of today's list, my lord.
Yes.
My lord, in this matter, Mr. Shaunak Bhattacharya appeared.
38.
138, my lord.
Calcutta will mention it.
My lord, grateful.
Expeditious disposal, Lordship.
No urgency, madam. Yes, call the list.
লর্ডশিপ আজকে আমার লিস্টে 374 নম্বর আইটেম তো লর্ডশিপ এটা যদি কালকে হয় খুব মানে প্রথম দিকে হয়
আপনি মেনশনিং স্লিপে আর্জেন্সিটা মেনশন করে
আর
দিয়ে দিন,
লর্ডশিপ আমার ওয়াইফের
লিখে দিন, স্লিপের মধ্যে লিখে স্লিপটা দিয়ে দিন।
I do not want to keep my learning senior friend, but this other matter, but was a continuing matter, but in the determination what was having. Worship, but heard this party.
I do not have any determination to take up writ petitions.
That Mr. Mukherjee is.
আরে কতগুলো কিছু নেই।
The matter, Worship may recall that matter regarding
So
land.
what do you want? I have signed the order.
Worship, I have not written ballot that can be heard by this bench.
Cannot be because I don't have determination to hear 226.
No,
Last one has been added.
Matters are assigned.
Can I take a chance for assignment?
Kindly,
This is the matter which is not assigned. The matter which Mr. Dotto is mentioning
yes, Mr. Mukherjee is doing that matter.
is assigned,
I not sure.
Lordship had marked it under the heading continuing matter, not party.
not assigned.
But may I take a chance for assignment?
Certainly.
I'm grateful.
সেটা তুই জিজ্ঞেস করছিস কি?
It will be difficult because this is a heavy determination. So
Lordship,
that is
only Lordship knows, Lordship has heard it extensively and it's only at the verge of.
yes, call the list, call the list.
ওটা সিটটা দিয়ে অ্যাসাইনমেন্ট চাই। ফাইল নাই তো।
Yes, Mr. Basu, what did you tell him? Whispering in his ears.
No, that's not for my lord. My lord has changed the camp.
I could
I remember it.
I could read your movement in the of the lips.
Some advice, free. To get this matter heard by my lord.
Don't do that because you are a senior advocate.
Why not?
Read.
কত ফ্রি যাচ্ছে?
Yes, who is appearing? Yes, what are you challenging?
Order passed by the learned debts recovery tribunal.
Debts Recovery Tribunal. Go before the appellate tribunal. Appellate tribunal is functioning. It's functioning.
Absolutely, man. But only the point of
Where
jurisdiction.
are those judgments, Mr. Dotto? You will scratch your head now.
Only on the.
He will take the point that alternative remedy is not a bar. We have
only
not
on the-
brought that judgment where the Supreme Court has considered that and observed that no, where there is a, we will not bring those judgments.
Only on the point of jurisdiction. Even your lordship can decide.
Yes, so that is a good ground for entertaining a 227. But this Honorable Supreme Court has said no, even then should not. You will not bring those judgments.
On the earlier occasion, your lordship's coordinate bench had gone into this,
And entertained.
entertained and passed an order.
Mr. Dotto, I am bound by the division bench judgment.
But
I am a party to that
yes,
judgment.
but therefore I have not brought those judgments since this has been entertained by this honorable court. Your lordship, if your lordship so desires, I can bring, but there's no point.
Repeatedly, the Honorable
Yes.
Supreme Court bring those judgments. Tomorrow, to be mentioned.
All right, my lord.
You have not brought those judgments. Have you seen those judgments?
Not yet, my lord.
Mr. Dotto, give him those judgments so that he can go through that. If he can distinguish, also bring the judgment of delivered by the Honorable Chief Justice. I think last week or the week before that. On this issue, considering the latest judgment of the Honorable Supreme Court, wherein this was considered that alternative remedy is not a bar. Considering the, quoting that paragraph, it was thereafter held no. In surfacey matters, don't touch. That is the exact language.
It's a self-imposed restriction. No one can say 227 is barred.
Well, Mr.
That's
Basu,
it.
you have seen, you are
It-
aware of
it is
the
that.
recent decisions
Thing is,
deprecating the practice and mentioning the name of the high courts.
maybe. But one
So-
thing is entertainability, another thing is to go into thereafter. No one can say it is not
So that
entertainable.
is the discretion of the court.
Yes. Second limb is there. First limb is, my lord, no court can say. Even the Supreme Court cannot say.
The recent judgments are,
Yes. Try to, my lord.
that is why I asked Mr. Dotto, kindly go through that judgment. Mr. Dotto, give him those judgments so that he can. I think one of the judgments was authored by the previous CGI.
One is South Indian Bank is there.
South Indian Bank is much earlier, thereafter. Yes. Not today. Next. File panni. Call করুন একবার তো দেখা যাক।
for the petition, my lord, I am appearing.
File has not come. Since you have mentioned it was expiring today, I have listed, but file is not here. Without the file, it's come at 2 if the file comes.
My lord, kindly
It
keep
is
this
expiring
matter-
today or tomorrow.
My lord, kindly keep this matter tomorrow. My lord,
Is-
we will finish.
When it is expiring, today or
My lord,
tomorrow.
it has expired.
It has expired. তাহলে not today করে দিন। When it has expired,
My lord, expired in June. I have filed it.
June. So this is an
Section
application.
24. Section 24.
This is an application. তাহলে এটাকে application heading এ দিয়ে দিন। List this matter under the heading, আচ্ছা লিখে দিন। The learned advocate
Application is for, my lord,
ওটা record
restoration and
করবেন কোথায়? ফাইলও তো নেই। Not today করে রেখে। Yes. Call the next matter.
my 3 same.
3 same. Not today. Next.
4 is also same.
Not today.
5 same.
Not today.
6, my lord, I am for the petitioner. This was,
When it is expiring.
it is expiring on 28, but it was fixed
28th.
28, it was fixed on 19th of,
All right. So I'm making
February
it not today. The file is not here.
yes, yes. Your Lordship.
Not today.
Yeah.
Who is your other side?
Nobody was appearing. There was a direction to serve notice once more. We have served, and that is why I mentioned it.
Section
yesterday.
24,
Section
transfer.
transfer.
Yes.
Specifically appearing as 19th February. That is
Next.
tomorrow. Grateful, Your Lordship.
So when will not appear for the petition? That seems
Same. Not today. Next.
for the opposite party. Well, let the matter appear under the application. Application.
Because no order can be
No order
passed.
can-
File is not here. I was about to pass that order, but file is not here. Yes, next.
Well, remove those things. This is not necessary. These things are not necessary for this code.
These things are not.
Petitioner, respondent, my lord, after hearing can understand who is petitioner, who is opposite party.
ওইখানটাতে কি
কিছু নেই, job এর বেকার।
রেসপন্ডেন্ট আছে নাকি?
হ্যাঁ,
লেখা?
respondent থাকবে তো। Read code, it was his code. তুলে
এটা
দেবেন।
দেবেন, এটা অপোজিট পার্টি করে দেবেন।
কিছু করতে হবে না, তুলে রেখে দাও, গুছিয়ে।
Well, in this matter, I am appearing for respondents. I am being led by Mr.
Respondents.
Uttuman
But
Bhattacharya.
I'm
Respondent.
appearing online.
Mister,
I'm appearing online. But I beg to appear online.
oh, you are appearing, all right.
Lordship,
Yes.
at the beginning, Lordship, I have one thing, Lordship. One reply to the written objection.
One,
Reply to the written objection in the appellate court has not been arranged in this year.
you have copy of that.
Not necessary.
Not arranged.
My lord, if I may suggest, my lord, if your lordship, my lord, the order is of June 2024. Directions were given to file their counter and to dispose of the matter expeditiously. My lord, till date they have not filed the counter. I appear for the plaintiff respondent. My lord, till date they have not filed. My lord, if your lordship can remand the matter back, it is against an ad interim order, and let them file their counter, and it can be expeditiously disposed of. Lordship sees the ordering portion.
Thank you for the
This
suggestion.
appeal has been disposed of.
Yes, yes.
No.
Can you hear me now?
Last, it is requested to dispose of the application under Order 39, Rule 1 and 2.
Order 39,
And
Rule 1 and 2.
I will do it for that, yes. But this is suit for declaration.
Mr. Basu, what is the stage of Order 39, Rule 1 and 2?
Nothing
This
is
is
there.
ad interim. They have not filed their counter.
No objection filed.
No?
Objection filed up till now.
So you have not filed your objection.
No, they are the defendant. I am the petitioner.
Before my lord. Miss appeal, then before my lord. But can you see, give me 5 minutes time. If my lord is not convinced, I will go back.
How long you will fight with the ad interim stage?
My lord, can you give me 5 minutes time, not more than I know. My lord is hard pressed with his time now.
That is
I know.
because, if it can be decided once for all in the
Okay,
injunction.
One thing, my lord, kindly, my lord has Tika Tenancy Act. Don't have it. Can you take my copy?
ঠিকা টেনেন্সি আনিয়েছেন?
দে না, আছে বুঝতে হবে।
I could anticipate what the learned senior counsels will, which books, which statutes they will refer to. জানেননি?
Well, kindly come to section 5, subsection 3.
Yes.
If any question arises, so it is after the objection is filed, a issue cropped up. If any question arises as to whether a person is a Tika tenant or not, or whether the land in question is Tika or not, the controller, either of his own motion, decide. So earlier stand change, now controller has to decide. Now kindly read this section along with section 21, the bar.
Civil court's jurisdiction.
Here, my lord, suit has been filed saying that I am the HON'BLE landowner. I raised a question giving the permission from Tika controller. My name is in the Tika roll. I made an application for sanction plan as a Tika tenant, granted with permission of Tika tenancy, Tika controller. That issue was raised. The court has
That
sought
issue
to
was raised where?
the ad interim stage with my objection.
In the miscellaneous appeal.
Appeal. So red court partly decided and then granted an ad interim order which refused by the learned single trial judge.
Where is the order of the trial judge?
65.
65.
5. Asen go.
Yes,
65.
69, sorry.
Mr. Basu, you are accepting the civil division briefs where the trial court certified copy is not being filed.
Now my lord is saying, this is the same statement I am making. After Justice Biswajit Basu, none insisted on that. How the junior will learn?
You are there, Mr. Basu.
How can be done brief?
When you are accepting the brief,
After
you
it
should
is,
have told them.
after it is, sometimes my lord knows how the briefs come. Next following day, matter is urgent.
No, maybe.
I can
But-
grant leave to file it. The rules is not amended, but nobody is judges are not saying.
So after all, you who have to.
I know. Well, my lord, the court has no duty.
Yes,
The court is not insisting.
but you also owe a duty.
Certainly, I am not.
Accepting the brief.
I am not struggling my responsibility. Yes, I have also. But sometimes it
When you-
happens.
Mention the page number, I was sure that the certified copy is not here.
This is called experience.
So it also struck you. You should have told them, but you have not told.
Yes, my fault. In so many matters I have told. In this matter I have not told. I am sure.
Yes.
Can you read that? Can you come to the bottom, last paragraph? I peruse the petitions, application and supporting documents. On perusal of the document, it appears the plaintiffs who were claiming to be Khas Mahal land holders have not produced any document in regard to their title to the suit property. They have not produced any patta in regard to the suit property. If at this stage an injunction order is passed without hearing the other side, the inconvenience caused to the defendant will be irreparable. My lord knows Khas Mahal lands are Khas Mahal land is like my lord any other land of an individual. On the penultimate date, 1954 April, 55 April, the Khas Mahal land also vested. Who was in the possession? They became the right. Khas Mahal land is no other dimension. On this, my lord, appeal has been preferred. Now, kindly come to the appeal court's order. After objection.
No, after objection.
No,
they,
objection filed.
they filed a miscellaneous appeal.
They are with objection.
So in miscellaneous appeal, you have filed an objection.
Fine.
So what happened? Miscellaneous appeal ad interim refused. Miscellaneous appeal ad interim.
Ad interim also granted and finally also.
Ad interim granted. Thereafter, you filed objection.
Yes.
Yes.
Now, my lord.
Show me your
if
objection.
If your lordship
from
want
this
to,
order itself.
I'm showing. If your lordship want to read the entirety, I have no problem.
Show
I
me
will
your
show
objection from this.
Kindly come to the third page.
Third page. Yes.
Only decision has been referred. Second line, it kindly will challenge with you. It was also observed that assessment. Second line of third page.
From the top.
Top.
In support.
Fourth page.
Sorry.
Oh, Baba, no. My lord,
fourth page.
Second, third.
Page number you will get at the bottom.
Fifth. No, my lord, it is not with my copy.
Where are you?
My lord, lordship kindly see. However, decision rendered in the case of Sosi Enclave. Fourth paragraph.
Sahi Enclave.
Sahi Enclave.
Page 4. Page 4, last paragraph.
I turn over the page. It is also observed. Second line. Second line.
Yes.
Also observed that assessment record of KMC do not establish a thicker tenancy unless the ingredients of the provisions of 49 Act or the provisions of 2000 Act are fulfilled. He is going to decide that question.
Yes.
He cannot do this. Suit is barred. I need not go to any other point. This issue cropped up.
Show me your objection.
Yes, my lord, kindly come to 155. Yes, kindly come to 156. And I'll show the two documents. Hurriedly, I will show to you, lords.
156.
Paragraph 7, subparagraph A. That Neil Krishna Pal alias such and such was a thicker tenant in respect of all that plot of land measuring 16 katas 9 series or more or less situated at premises number such and such. As a matter of fact, said Nalini Krishna Pal Neil Krishna Pal was let out the said plot as a thicker tenant by the landowner such and such sometime in the year 1958 and since then had paying ground rent to the Jamindar such and such. B. The said Nalini Krishna Pal raised dwelling structure over the land measuring of such and such. My entire case is based on thiccer tenancy.
Yes. Where have you said about this bar of jurisdiction?
It is need not be said. I will show to Lordship two documents. If your Lordship kindly give me 2 minutes time, I will show to Lordship two documents.
Should have raised this plea, Mr. Basu, that the suit is barred.
Yes,
You have not
it's a
raised
question
that.
of law. On the admitted pleading, if the suit is barred, will kindly come to
You have not argued also before the
232.
miscellaneous appeal that the suit is barred.
kindly recall 65 Supreme Court. I have not said anything else.
But you have not
232
raised.
Even when the CO was moved, the point which was taken was
But
not
এখন-
by limitation.
রুদ্র চুপ কর এখন
Yes.
232
232.
two documents I will show. This is the permission from the thiccer tenancy authority allowing the thiccer tenant to raise this construction. On the land in question.
So according to you, this is a prima facie doc. So you have made out a prima facie case.
I have made
Otherwise-
a provision says to dispute that is a thiccer land. If I am able to show that
And
thing,
you have produced some document in
Yes.
support of your objection.
this is the 132 and 232 and then kindly come to 229.
What is 229?
Yeah, kindly see assessment register, IB register, my lord, RTDH, dwelling house, thiccer tenants, thiccer land, and another document is there. Where who will make concern? কোথায় গেল সেটা? 214 ব্যাস আর কিছু দেখাবো 214 আর কিছু দেখাবো
229.
my lord, seen that. And
Tenant.
lastly, kindly come to 200.
Virendranath Paul.
Yes,
He is your predecessor.
predecessor. Now kindly come to 214. Nothing more. I need not show to Lord. Thiccer controller mutating my name, certifying that is a thiccer land. Other points are also there, my lord. When the trial court has refused, appeal court will be slow to otherwise my
Mr. Basu, show me that you have pressed that the suit is barred on this
my
ground.
lord,
Before
I
this.
might debarred, my lord, from raising for the first time.
I'm
If
not,
in Supreme Court
I'm
I
not
can.
saying so. So why did you not raise? I'm asking you. I'm not saying you are stopped or you,
It has
there is a
not
bar.
struck the mind of the lawyer. If I can show to your lordship, my lord,
So I will allow you to raise that point in the
my
injunction.
lord, 227 your lordship can. Lord, that's why I bring a judgment.
Basu,
No, my lord.
the
2004 1 CHN kindly see.
you could have
Court must be
cannot say something. You could have taken another step. Everything would have been by this time.
2004 1.
Now everything would have been decided.
My lord,
If you had taken the other step.
2004 1 CHN there. My lord, your lordship's court had held that before giving cognizance to a proceeding, court must be satisfied it has jurisdiction. Can you take note? 2004 1 Calcutta High Court note.
The injunction cannot be granted unless the proceeding is maintainable.
Yes.
That there is no dispute to that.
This is, my lord, that's
But-
why we want my lord to be in this jurisdiction.
Don't say so. But the question is, you also have not raised that point. That is, you have not
This is
raised.
court's duty. My lord, the court has said that your lordship's court.
Not your duty. Mr. Basu, it's not your duty.
It said,
I'm not saying your duty here.
no. 2004 1 CHN 498 specifically said court must be satisfied. Like my lord, section 100. Who is to formulate? Court has to formulate. We formulate. কি রে?
So
কি
that
দেখছিস এসব? হ্যাঁ? এই জাজমেন্টটা কোথায়? 2004 1 CHN
2004,
1 Calcutta High Court notes 498 paragraph 18
1 Calcutta High Court notes, page
498. The division bench judgment of Justice Dilip Seth was presiding.
it referred to any Supreme Court judgment.
Ah.
Kindly check up.
Just a minute. Dilip Kumar said Rajendranath Sinha. So kindly, paragraph 18. বই বই আনিস না কেন? It is too much.
অনলাইন ক্লাস করেছি
এটা কি?
অনলাইন থেকে করেছি
Paragraph
18.
ডিলিট সেট
কি করব? এটা পারবো না। And this is for my residential plot. This is not promoting. So, my lord, this is my submission. If on the face of it, quote, the plaint is not entertainable, I am not.
But
Here in this
the
case,
appellate court,
1 second, my lord. Here in this case, I cannot say the plaint is not entertainable. The language in section 5(3) is if the issue cropped up. Issue cropped up. On my objection, issue cropped up. Then court will extend himself in terms of section 21.
is because before passing an order of injunction, the court has to be,
Satisfied that it has jurisdiction. It has not barred. Here it is under section.
IMFSC case also
Include
is-
that.
include that.
I nothing more to add. Let him say.
Why you stopped at that?
My lord.
Why you stopped at that?
My
What
lord,
further
that-
argument you want?
No, another judgment is plan sanction 2008-11 SCC page 1. Plan sanction 2013. I am going to construct some construction made. Then court will see a balance. Those judgment may not be necessary if your lordship is.
Here it has been, you have been injuncted from constructing.
Yes, status quo means everything goes. I have a residential plot. I have got a sanction. Not for any promoting, for my own accommodation.
Status quo, nature, character, possession.
Everything.
Possession you are not affected.
No. Possession, my lord, I will
You are
be.
not affected, but
Can I-
nature and character
For the
affects. you.
time being, can you maintain the possession? I will not possession. I will.
That is why possession is
No,
not affecting
no.
you. Nature and
Allow
character
me
that
to
affects.
construct.
That
I have a
affects.
sanction plan. I think, my lord, I will not waste your lordship time.
Yes, Mr.
But
Bhattacharyji.
may I have
But
another?
first of all,
Next,
kindly
Here, from here,
next matter.
come. There's no door, Mr.
No, my voice can reach. Just coming.
Yes,
kindly comes to the impugned order. But
yes.
on internal page, 1, 2, 3, 4, 5. 5, second paragraph. From the four corners, has your lordship?
Internal page 5
Yes, my lord.
from the four corners. Yes.
For the four corners of the injunction application before the trial court, no statement has come as to who among the 60 persons, as per mutation proceeding before the collector's house 24 Parganas, was in possession or the manner of their possession. At the same time, there is no indication as to how and when the defendants managed to take possession of the suit property before initiating construction activity. From a conjoint reading of the decisions referred by the appellant, and on perusal, it can be said that the appellants have raised a prima facie case of their interest in the suit property. And my lord, for a limited period, the order of injunction was granted and requested the trial court to dispose it off within 2 months and directed them to file the counter. They have not done it till date. But it will kindly see.
But what is your submission with regard
Yes,
to
my lord, I will come to that.
Civil
Yes,
code?
my lord has the Thika tenancy rules, my lord, of 2004.
Thika tenancy rules.
Yes.
Just because I say I am a Thika tenant won't make me a Thika tenant. They have to.
No, it's not that
Decide.
because the not by saying there are some documents which have been annexed.
My lord, kindly comes
So
to
that Thika controller has
West
mutated
Bengal Thika
their
tenancy
parameters in their favor.
My lord, West Bengal Thika tenancy My lord,
Which-
West Bengal Thika tenancy acquisition and regulation rules 2004.
Yes,
My lord, kindly comes to 3A, rule 3A. Have they done it? Let them show before my lord. Every Thika tenant shall furnish to the controller a return in Form A separately for each holding of tenancy, showing the particulars of occupation of such land in total within 240 days from the date of commencement of the act. the controller may on a written application from such TICA tenant extend the date of furnishing such return by a period not exceeding 60 days. Have they done this? Let them show.
This court will decide that.
Have they done this?
This is for you to take that point before the controller. If according to you, the
To establish TICA tenancy, he has to file this application.
Bhattacharya, he has produced some documents, prima facie. We are at the prima facie stage.
Why not?
They have produced some documents which shows that their names have been mutated in the office of the TICA controller, and the TICA controller has granted permission to construct. These are the two documents which goes to show prima facie that they are the TICA tenants. The appellate court ought to have decided that issue before granting an order of injunction.
Did they raise this objection before the appellate court?
Yes, yes.
The suit is not maintainable.
Yeah.
No, did they raise that the suit is not maintainable?
No, may not be, but they are the TICA tenants. If they are the TICA tenants, the first appellate court is deciding an appeal from an order
that has been
passed by the
considered.
honored civil judge from a suit. So that goes to the root of the jurisdiction.
My lord, that the learned court has, in my respectful submission, has decided. May I just then have to read the judgment?
Yes, yes, yes.
Or may I come back on some other day, my lord? May I come back day after? I want to do it physically, my lord. I want to come and do it physically.
See, I am for some other other respondents, other plaintiffs, appearing for other plaintiffs.
Other plaintiffs?
There are four plaintiffs.
So plaintiffs
There are four plaintiffs.
segregated, appearing to different lawyers.
No, yes, he is submitting as they are, but I want to submit something.
No, it's unheard of.
As per my understanding.
Plaintiffs are jointly proceeding before the
Yes.
learned trial court and proceeding differently before the High Court.
See, I have something to say.
I have not heard. I don't know whether Mr. Basu has heard this.
No, that's because
I am hearing this for the first time.
let me
This
show-
shows that the plaintiffs are not at one.
No, there are four plaintiffs here.
Who plaintiffs? All are plaintiffs. Before the trial court, they are conducting their case through one advocate.
So see, as per my understanding, I want to submit something. Now up to you, Lordship. Kindly say, see page number 117.
All right, let him, he wants the time, so Ashwin.
Available.
My lord, due to the hard press, madam, my lord, this is the matter. I have concluded, my lord, kindly keep in such a position, madam, can be taken up.
Mr. Basu Lanet, senior advocate, appears for the, concludes his argument for the petitioner. To stop. Mr. Bhattacharya Lanet, senior advocate, appearing for the, which opposite parties?
But I was instructed that I am for all the plaintiffs. Plaintiffs cannot have representation through different lawyers.
But your learned friend is saying,
Only want to
I
add.
do not know, my lord.
want to add something.
Yes.
All
এটা
right.
বল না।
I file Bhogaladam on record.
Yes,
He is my senior also.
for all.
To add something, that's fine. But
All right. কি বলো, represent, appearing for the opposite parties.
Lordship, before that, kindly say, may I say one line, Lordship?
Yes.
The bill they have submitted before the TICA, not of us. We are the permanent settlement land
All right.
of 60
That I will
acres,
consider.
Lordship.
Yes, yes,
That is the dispute.
This is the dispute.
They issued the bill, not of the Jamindars. As per record, as per
Let the
RTI.
first appellate court decide
This is
that
the issue.
issue.
And number,
I can remand that
And
first
it-
appellate court decide that
Yes,
issue.
And it-
Lordship, next
But
Lordship.
then the
yes. Let it be remanded. Let it be remanded.
First appellate court to decide this.
yes,
Yes, my lord.
ঠিক আছে।
the entry order.
And
and-
next bill of the
But the
plain-
interim order may not. The interim order may be continued.
But has to go. Has
Certainly
to
not.
go.
No,
No,
Lordship.
then my lord, kindly may I come back on?
If you say, because if the order is set aside,
No,
I cannot want keeping that order intact.
Cannot be.
So if that is so, the order has to go. Mr. Bhattacharya Lanet, senior advocate, appearing for the opposite parties, makes his opening submission, but prays for an accommodation, expressing his desire to make submissions
Physical.
physically in court. Full stop. As prayed for by Mr. Bhattacharya, Lanet, senior advocate, list this matter. Matter সামনের সপ্তাহে কবে আছে?
ডায়েরি ভর্তি হবে। Henceforth, there will be no slot available.
একটা আছে 25 তারিখ
This is a very short point.
25 তারিখ
Could it be 26th, 25th?
No,
I-
25th of
No, no,
Feb-
25th, I am not in town. Could it be 26th?
26 দেখুন তো 26 ফাঁকা আছে কিছু নেই তো 26th
Grateful, madam.
February under the heading returnable matters
26 my lord, শিবরাত্রি।
আর দূর বাবু আমাদের কিছু নেই। বিচার
শিবরাত্রি।
করতে যাবি নাকি?
No, no.
শিবরাত্রি
As per the calendar.
you will perform শিবরাত্রি Mr. Basu, you are filing this affidavit service today
Yes, yes, yes.
এই রেকর্ড করে দিন তো affidavits of service why two
Oh, once they have taken up long after long time. Second,
affidavits of service filed in court today are taken on record yes yes this book only yes call the next matter oh CH in touch yes call the next matter
I am for the petition in this matter. This is with regard to challenging an order passed in under section 24 pending application, which is awarded initially was for.
who are you
I am the husband, my lord.
I am the opposite party wife.
you want reduction of the amount
Yes.
you want reduction of the amount what is the amount which has been directed to-
Earlier, my lord, that was a 14,000. Now it is enhanced to 25,000. Now
what is your income
my lord, I am in
what are you doing
75,000 my lord, per month, my lord, my income with regard, I am a central government employee. My lord, kindly come to my lord, the order.
25,000 you can
My lord, 1/5 of the my lord, your lordship kindly see my lord, 1/5.
1/3 is also there
My lord,
for the court to
my
act.
lord, I have
I'll just take 5 minutes.
my lord,
Just take 5 minutes.
Let him submit sir
my lord, on 14th of March.
you have a chair behind you you have a chair behind you take your seat
My lord, on 14th of March 2024, my lord, this honorable court, my lord, on the basis of the application filed by the, my lord, the opposite party wife at page 11, my lord. Your lordship kindly take, my lord, page 11.
page 11
Page 11 or my lord, after the affidavit page, my lord.
yes
Page 11, kindly come to the bottom portion, my lord. The wife seeks transfer of a matrimonial suit number, such and such, which is pending before the learned district judge at Paschim Medinipur to the court of the learned additional district judge at Kolai Nodia. The husband does not oppose such pair. The only contention of the husband is that the matrimonial suit should be expedited. Under such circumstances, the application is allowed. The court directed learned district judge Paschim Medinipur to transfer the records of the case to the learned district judge Nodia. And the learned district judge Nodia shall assign the suit to the any competent civil court at
what is
Kolai.
the stage of the suit
Well, after the pending application, my lord, the
what is the stage of the suit now
issue, my lord, issue was, my lord, issue was not in framed, my lord.
issue has not yet been framed
My lord, now, my lord, what has happened? The order passed on 14th of March 2024. My lord, the order passed by the, my lord, the impugned order, my lord, that is after the order when the honorable court was directed to transfer this matter from Paschim Medinipur to, my lord, the Nodia. Now, my lord, on 22nd of April 2024, the impugned order was passed after the order passed by this honorable court.
yes
My lord,
what is the
the
difficulty
Paschim Medinipur, my lord, the section 24 application was disposed of. My lord, on that date, when the court was directed to transfer the matter from Paschim Medinipur to Nodia, now on the 2nd of April, my lord, the Paschim Medinipur court was disposed of the section 24 application.
so according to you it is without jurisdiction
My lord, that is, my lord, my first contention, my lord, because this honorable court was directed, my lord, to transfer this matter on 14th of March 2000, my lord, 24. That is at page 11.
I can accept your submission but that will only delay your suit
Well, I am paying my 15,000, my lord, till date.
that will only delay your suit it's after all your choice I can direct the transferee court to redecide the matter but it will only delay your suit choice is yours
Or may I come back to take instruction to this matter?
what instructions no instructions I'm setting aside I'm giving Yes, because it could not have been done because it has been transferred.
My lord.
Only on the jurisdictional point, I am setting aside, directing the court below to
I-
rehear.
My lord, reduction of the quantum of maintenance is not in their prayer. Kindly see page number 8.
He's taking the question of jurisdiction.
No, my lord, let me place some documents, server copies of the orders of the trial court below. You will understand everything from the timeline of the orders.
Sir, have you understood his point?
Yes.
What is his point?
His point is that case was already transferred by Honorable
Yes.
Justice
So
Sampar
this
Sarkar.
court, Paschim Medinipur did not have jurisdiction. So it's without jurisdiction, he is taking that plea.
My lord,
After the High Court has transferred the proceedings.
my lord, it was a fault on the part of us. I admit, I candidly admit that.
That is why I am setting aside directing rehearing of that application. You raise all points there.
My lord, that will be causing injustice to the little child and her mother.
Why?
I'm paying, man.
14,000 is the husband's salary is 75,000.
14,000 they will pay. I will direct them to redecide this matter. Maybe it can be enhanced.
My lord, he's evading the execution proceedings. He is not receiving the letters. The address that he has given in his cost title.
Is there any default as of now?
Payment
Yes.
of the earlier order, 14,000 order.
14,000 order?
Yes, there were execution cases from the very beginning.
Yes. Pay the entire amount according to, in terms of 14,000.
The 14,000 order.
You have your calculation with regard to the areas. As per 14,000.
As per 14,000, no, the execution case number 35 is pending. It was calculated on the basis
I'm
of
asking you, previous direction was 14,000. Has he complied with that 14,000 or there is any default on
the execution case is still pending.
May I just know?
I'm asking you whether there is any default at the rate of 14,000. Yes or no?
Yes, of course. Yes.
What is the amount?
The ADR amount.
Yes, as per 14,000.
That I have to check, my lord.
My lord, we have, my lord, paying 14,000 as the current, and my lord, with regard to, my lord, that was also done by the trial court, 15,000 of the area per month. And total, my lord, 29,000.
What is the area amount left?
My lord, may I say one thing?
Take instructions, come tomorrow.
Okay. Tomorrow.
8,000, my lord, till, my lord, after payment, my lord, that is remaining 48,000.
48,000.
No, the maintenance from January 2024, December 2024 is not yet filed as a misexecution case. And they are paying 14,000 from the month of June.
The learned advocate appealing for the opposite party submits that the petitioner is a defaulter in payment of alimony pendentility, even at the earlier rate of rupees 14,000 per month. So, Mr. Bhattacharya, learned advocate appealing for the petitioner, however, disputes the submission of the learned advocate for the opposite party. List this matter in the next week when the parties will come with a statement.
My lord, it's very urgent. SLP is pending in Supreme Court.
Against what
SLP,
order?
my lord, my
SLP against.
application of visiting right, that was denied by the trial.
And neither here nor there SLP.
And she has been reduced to destitution. She cannot contest the SLP in the Supreme Court.
That is a different thing altogether.
My visiting right was denied, but that was
At least, my lord.
If you say so, I can decide this on the question of jurisdiction itself. If you insist, I can decide this. It's only since you have said that there is area, I'm adjoining it. Otherwise, I will decide it on merits.
Kindly fix a very short date. I'll come with the calculations.
Next week, I'm saying.
My lord.
Come with definite instructions as well as statements in support of their respective claims. This is on next week, bolechi to? Next Tuesday date diye di. Next Tuesday.
And develop.
Yes, next.
Yes. Your Lordship, I am appearing for the petitioner defendant. There is a caveat I have served.
For the caveat.
Yes. This is the affidavit of service. My lord, matter relates to a partition suit filed by the plaintiff. Claim 1/3 share 9.1 out of 20 shatak of land. Now there is an order of injunction. Now after the order of injunction passed ex parte, which normally happens, My lord, your lordship kindly comes to page 41. Without modification, an application under 151 was taken by the plaintiff. It starts from 41. If your lordship kindly comes to the relevant part, my lord, may I place page 44? My lord, if your lordship escape last 4-5 lines at
Page 44.
page 44
Yes.
of the same application. At first, the miscreants created one wall. Your lordship got, my lord? Your lordship
So what is
escaped?
the impugned order?
Yes, impugned order. Just a minute. Your lordship, my lord, that is after page 54,
Yes.
9th of 12/24, to remove the pathway which was agreed between the defendant number 5 and plaintiff. This is the impugned order. It is also expert. Everything is expert. Your lordship kindly goes to the impugned order. The ordering portion is at the next page. May I place, my lord?
Yes.
That the defendant number 5, that is
Give me a minute.
just a minute. Yes. আমাদের রেকর্ডিংটা কোন পাতে আছে? হ্যাঁ? ধরো 50।
Yes.
Now, your lordship kindly see the next page ordering portion. That the defendant number 5, that is my client, Irfan Ghazi, is directed to clear the illegally construct pathway at the southern side of the suit plot, being east-west direction, and restore status quo, which is still forced, still dead, upon the suit property. OC Swarupnagar PS is further directed to remain present at the relevant time.
Show me the status quo order.
Yes. কত পাতা?
May I interrupt, my lord? My lord,
Yes,
this
sir.
has already been done, my lord.
I have to complete my argument, sir. You have done the illegality by the help of police. That is to be adjudicated by
Very well.
your lordship. Page 40.
40.
40, yes. Your lordship got, my lord?
Yes.
Ordered that the plaintiffs and defendants are directed to maintain status quo as on this date with regard to the nature, character, transfer, and joint possession of the suit property till 2/9/24. The defendants are directed to refrain from creating any construction as well as any fencing over the suit property. Now, your lordship kindly,
This was an ad interim order.
yes, I'm grateful. Now,
Yes.
151 was, my lord, filed. No modification, no violation under order 39 rule 2A. As far the case of the plaintiff goes, that I have violated the order. Nothing like that. Now, your lordship kindly once comes to the impugned order. Once. Your lordship kindly see, my lord, the last portion of the impugned order, that I tendered my appearance on 9th of January 25. Your lordship, on the same page. Your lordship,
Which page?
my lord, the last page of the impugned order, that is the
Yes.
ordering portion. Your lordship got, my lord? 9th of
Last
January.
page.
Record is put today,
9th of January. Yes.
25. Order is passed, ex parte, that is
But
what
defendant number 5.
I am the defendant number 5. Kindly
Yes.
see, my lord. The defendant number 5 is appeared with a wakalatnama along with a petition, files a written statement. Copy served, let it be kept with record. The defendant also files a petition praying for recall of the order number 7 on the ground stated therein. Let it keep with the record. Heard learned advocate for the defendant, no compliance report is received from OC Swarupnagar. Considering the urgency, fixed 3rd of March 25 for hearing petition and fixing WO in the meantime. So, with greatest respect, my lord, I am submitting when 3rd of March was fixed by the learned trial judge, and I have filed the recalling, which starts from page 44 onwards. My lord, the damage has been done. My lord, a notice was served upon my client no date by the my lord OC, and my lord it was removed.
What was removed? Road.
The road removed during pendency of.
Why have you constructed the road in violation
I
of
have
the order?
not constructed.
It was there.
It was there. I have, my lord, annexed the agreement also between the plaintiff and the defendant number 5. That is not unregistered, but there was mutual.
Where is that?
Yes, yes. Just a minute. হঠাৎ করে চলে এসছে unregistered. Just a minute, my lord. Kindly give me, yes, page 29, I think. 29. 29. Yes, I'm grateful, my lord. Page 29. It starts, kindly see, my lord.
No, whether this, according to you, this agreement permits you to construct a road.
I have not constructed. The road was there all along. We are both of us, the plaintiffs and the defendants, and also the neighbors are
No,
enjoying
this
the road.
agreement permits the parties to construct the road.
Yes, but I have not made any construction. That was already there. And in my written statement, I have categorically stated that the plaintiffs.
Yes. But now the road has been.
Yes.
What remains now?
And the more, my lord, the unfortunate incident is that.
But what order you are not expecting from the court? Damage has been done.
Damage has been done. Being an officer of the court, I must, my lord, submit the true facts of the case, my lord. So your lordship kindly directs to heard the recalling application at the earliest, my lord, and decide which version of the case is correct or not. Because, my lord, the unfortunate part of this case is that the learned trial judge himself, my lord, fixed recalling application. I may successful, I may not be successful.
So that is recalling application has been fixed after that.
Yes, but during
previously there was an order for removal.
Yes.
Yes, how could it be
come.
done without serving ad
May I
interim
say,
order,
Lord?
implementation, everything,
May I say,
mandatory
Lord?
injunction, everything without
May I say,
service?
But 1st August, my lord, the order was passed. He was served thereafter. He has chosen not to appear. And my lord, thereafter, he has chosen to violate the order of injunction.
Show me what was the status of the property recorded in the ad interim order of injunction.
I do not find any.
So,
My lord,
so how could the learned
But
court
the
be
order-
hold that there was a road?
the order impugned was passed, my lord, considering the CCTV footage.
So if the parent order does not record the character of the property, how the learned court below could have directed restoration to its previous
But by
position?
the ad interim, my lord, the court has, my lord, restrained them from making any construction. And the CCTV footage shown that from morning 8:30 till night 10:30.
What prevented you to make this prayer after serving notice upon them?
But they were not appearing in spite of service.
Not correct.
Yes. kindly see-
Whenever I
Does
can
The record order does not record that.
The track report I can submit before my lord if required. Kindly see the order was passed on 1st of August.
and recalling
39
was
rule.
there.
Where is the recalling application?
Yes, page 44. My lord, just a minute. Recalling.
They have filed this revisional application after a period of 2 months, my lord. Kindly consider this.
No, not correct. Yes, I'm stand correct. Page 50.
50.
50. Page 24 টা লিখে রাখো।
9/12/2024. That is the ad interim order.
Yes, and I
That is the
appeared, my
order
lord, I have
under
shown.
section 151.
জজ সাহেব জিজ্ঞেস করে আমাকে বলতে
Ashun. This application under Article 227 of the Constitution of India is at the instance of the defendant number 5 and is directed against an order dated 9th of December 2024 passed by the Learned Civil Judge Senior Division Bosirhat in title suit number 486 of 2024. By the order impugned, the application under section 151 of the Code of Civil Procedure dated 4th of October 2024 filed by the opposite party numbers 1 to 3 herein was allowed, and the petitioner herein was directed to clear the illegally constructed pathway at the southern side of the suit plot being east-west direction and restore the status quo which is still in force till date upon the suit property. Mr. Mitchell, learned advocate appearing for the petitioner, comma, in his usual fairness, comma, submits that the who has removed? The plaintiffs have removed.
Yes, by the help of police.
Submits that in the order dated 9th of December 2024 has been complied with. No, submits that the plaintiff / opposite parties herein removed the pathway pursuant to the liberty granted by the learned trial judge by the said order. Therefore, no useful purpose will be served by keeping this application pending. Accordingly, the same stands disposed of with liberty to the petitioner herein to move his application for recalling dated
9th of January 2020.
9th of January.
dated 9th of January 2025, which is pending before the learned court. The learned court below korben before the learned trial judge. The learned trial judge is directed to consider the said application and dispose of the same after giving an opportunity of hearing to the respective parties. Affidavit of service taken on record.
My bad luck, I don't get your lordship earlier.
Yes.
Well, my bad luck, I don't get your lordship earlier.
Yes.
Otherwise, matter would have been different, man. Anyway.
Yes, next.
My lord, I am for the petitioner in this matter. My lord, this is essentially for modification of an order of visitation. My lord, passed by additional district judge, my lord.
No caveat. There is no caveat. Why you want variation?
My lord,
you are the husband or the father of the child.
I am the father.
Father.
And the minor daughter, my lord, is with the mother, my lord. Right now in
Second and fourth Sunday,
yes,
you have to visit the place. What modification you want?
My lord, the modification I want is, if it is practicable, every Sunday. And my lord, this liberty that has been given, liberty to the opposite party to remain with the child throughout the exercise, my lord, this is being regularly misused, my lord. This part. And also, my lord, this video conferencing once in a week, my lord, it can be every day at a convenient time.
First, start with 1 day in a week. If you find, yes, the child is also interacting with you,
No.
then you can.
She is, my lord.
So, it's better you start for the present once in a week. It's better to start with the video conferencing. Did you start with this visitation as per this order?
Yes. I have started, and
it was successful or not?
Partially successful, my lord.
Always.
Because, my lord, they are bringing others. Even an advocate is
The learned
accompanying
advocate
them,
appearing for the petitioner submits that the petitioner wants a slight modification of the order dated 19th of December 2024, passed by the learned additional district judge, second court at Balasar, district 24, Parganas North, in Miss Case within bracket Act 8, number 184 of 2024. So, petitioner is directed to serve a copy of this application upon the opposite parties. Or if you want modification, I can give you liberty. You can file that application before that will expedite.
My lord, my instruction is that we have already attempted to file this application before the concerned judge. It was not taken, my lord. It is notarized on that.
All right.
That's why we have approached this honorable.
Upon the by registered post with acknowledgement due and file an affidavit of service on the next day. List this matter under the heading contested application in the monthly list of April 2025. Next.
Grateful, my lord.
Aja, aata likhe din. It is however made clear that pendency of this application shall not preclude the parties from complying with the from taking steps pursuant to the impugned order. Yes, next.
But I am for the plaintiff petitioner filed a suit for specific performance of contract. Now, in that suit, defendant entered appearance, initially filed Order 7 Rule 11. Now, as they are delaying disposal of the Order 7 Rule 11, I came up before this court. This honorable court directed to dispose of the Order 7 Rule 11 within
Disposed of.
Now, ultimately rejected. Now, what happened, I have filed the suit, specific purpose of contract on the basis of unregistered agreement, Now, for the purpose of impounding, the court directed that the record be, that the document be go to the collector. Now, sub-register submitted report. Now, that
you are not happy with that valuation.
No, I'm ready and willing to pay. Now, what happened, that order, that the report has come from the sub-register has not been recorded in the order sheet and not been communicated. Now, the defendant filed an application that I have not complied the order. Now, court said that no, it is a mistake of the court because that has not been reflected in the order. Now, court observed that I have to pay the amount. Now, difficulty is that
pay the amount.
Difficulty is that I filed an application that asks them to accept or give the account number where I have to pay. Because after this order, we went several locations before the registry, before the sub-register, they are not accepting. I want to deposit. This is my suit.
That Mr. Mukherjee, you have to approach the learned trial judge.
That I have done. Kindly
What
see.
did the learned trial judge say?
No order, kindly see. Today, I filed 2 applications.
Yes. No, where is your application?
My application.
Your application is 12th of July.
My application is
12th of July 2023.
Absolutely. But page 16, they have filed application for non-compliance of court's order, and my application at page 12.
You could have easily approached the office of the registration authority.
No, not. I have been told, the advocate on record in the court will along with he, because counterpart in his, they went, we are asking the tier from or the any account where we have to deposit, because it is I am suffering. But the court is saying, kindly see the last portion of the order. Court directed, kindly see, their applicant has been turned down because it is a court mistake that has not been communicated. Plaintiff is directed to make deposit of stamp duty in terms of the report of the additional district sub-registrar Shialda, White memo number 45 dated 15/2/2024 on valuation of suit property relating to title suit. So the amount has been mentioned. Number, I want to deposit because otherwise PW1 can be done.
No caveat.
No caveat, But your lordship can direct, I can deposit the amount. Other side will not be suffer. True, yes, yes.
So Mukherjee, how to be deposit? What is the procedure that is to be ascertained?
That is just because they went, the office, the staff is saying, when they ask the either QR code or any TR form or something.
Because the procedure, unless without, what is the procedure? Otherwise, if you deposit it somewhere else, it will not given credit to. That is the difficulty.
Not been clarified also, because my prayer is in the code below. Kindly see once, page 13. Your Honor, may be pleased to pass appropriate direction either upon the collector, Southern Papagona, for furnishing the account number.
Advocate who appears for the state, who appears for Mr. Owen Banerjee appears for the state.
No, there are several now. No, there are several advocates. If you
can take instructions on this. Where is Mr. Owen Banerjee? He appears for the state. He is in the state panel. Ask him to come.
Tomorrow
at 12 today. Pass করুন তো 12টা 5 minutes past 12. Ask Mr. Banerjee to come. Yes.
My lord, item number 39 for the petition.
My lord, I appear on behalf of the opposite party. Mr. Bhattacharya is leading me.
Appearing. Ashun, since I'm not inclined to take up this matter on personal ground, this matter stands released from the list of this bench. Let the papers be placed before the Honorable Chief Justice for necessary orders. Next.
My lord, learned advocate, Mr. Pinky Shah is lying ill, my lord. So should
Learned
advocate on record, my lord.
Huh.
She has not come, my lord. I have prayed for, I'm praying for not.
She has not come.
Yes, my lord. Because I have instruction to pray for time. Let it be, my lord, next week.
You are appearing, you are here. After this, upgradation will be a different. Upgradation.
My lord, I'm only praying, my lord, that 1 week, my lord, that's your lordship. I'm praying for not this week, my lord.
Ashun, an accommodation has been paid for on the ground of the learned advocate on record of the petitioner. In view thereof, list this matter in the monthly list of April 2025. Yes, next. It is, however, made clear that the pendency of this application shall not preclude the learned trial judge from proceeding with the suit.
May it please your lordship.
Yes.
My lord, a very short point, my lord. A suit for declaration and permanent injunction. I being the plaintiff. My lord, upon filing the suit, my lord, I obtained ad interim order of injunction, which was extended from time to time, finally made absolute on contest till the disposal of the suit. Ultimately, my lord, my suit got dismissed.
Suit dismissed.
Suit dismissed. Suit for declaration. Injunction is a consequential, my lord, in the nature of status quo to the extent of.
Yes, what happened after that?
My lord,
title appeal.
I filed a title appeal. I moved the similar injunction application. My lord, in order to, my lord, continue the extension, my lord, of the injunction, my lord, to protect the nature, character, and the position of the property. The learned appellate court, my lord, dismissed my lord, rejected my prayer, my lord, on the ground that since the suit being dismissed, my lord, there shall be no ground of urgency. My lord, only the point is this, that this is not, my lord,
dismissed on merit. Suit was dismissed on merit.
But so far as the injunction is concerned, my lord, this is not a suit for permanent, it's a suit for declaration. So far my position is concerned, that is admitted even by the defendant in his, my lord, evidence. There is no, my lord, other way around. Only, my lord, my title to the property, my lord, that, my lord, could not impress the learned trial judge. My lord, I also rely on a judgment of a, my lord, Karnataka High Court, which got inspired a division bench judgment of this honorable court in case of, my lord, Novena Cinema, reported in AIA 1956. My lord, where, my lord, the concept of, my lord, an appeal or a revision, refusing ad interim order of injunction or, my lord, refusing injunction is slightly different from, my lord, in a case where, my lord, the injunction.
No, what is the date of the impugned order?
Well, kindly comes to page 75.
No, show me the impugned order.
Yes. Kindly comes to page 75.
Page 75, impugned order has to be a certified copy.
My lord, it has to be, my lord. Has to be. I also got, my lord.
Certified copy is here.
Certified copy
What is the date of the order?
My lord, February 5.
February 5, 2024, ad interim refused. Is there any scope to pass any ad interim order?
My lord,
you have served. Let it be heard out on a contested hearing, or I will direct issuance of notice. They will appear thereafter. It will be decided. Choice is yours.
My lord, may I only rely on a judgment?
Because urgency, Mr. Basu, 5th of February 2024, more than a year has passed. So urgency is the aspect while granting ad interim. Because you are wanting an ad interim today, after a lapse of 1 year. And when have you filed this application? 31st of January 2025. So almost a year after you have filed this application.
My lord, may I only, my lord, may I take lordship's 2 minutes time? 2 minutes time. Exactly. But kindly look into this judgment. I understand, Malad, there are some things, Malad, which may also go against me. But may I just,
Urgency has not to be considered.
Lordship?
Urgency has not to be considered. Mr. Basu, I'm asking you, these are the facts of your case. An interim refusal on 5th of February 2024. You have filed challenge that order on January 2025.
Malad,
Today we are on
Malad,
February
urgency,
2025.
absolutely, Malad, that is the one of the link,
So I can
Malad.
direct you to serve, but no ad interim order.
Malad, may I only then request, Malad? May I only? It's a very, Malad, what I have understood with my little understanding, Malad. If
Yes.
a Lordship even looks into this judgment, Malad, only this point Lordship may decide whether, Malad, this could be, Malad, considered. Kindly comes to, Malad, Malad, page number 7. Here, Malad, that the factual aspect are almost, Malad, similar. There, Malad, the parties
Give me a
interest.
minute, Mr. Basu.
My lord. There, Malad, appellate court granted injunction. That was challenged by the respondent defendant. And the point was answered and bifurcated the issues where, Malad, this is not a simpliciter appeal, Malad, under Order 43 Rule 1R. And, Malad, this appeal was dismissed, Malad, and my case is opposite. My appellate court, Malad, rejected my prayer. And here, Malad, this, Malad, our judgment, Malad, of this court, Malad, was very much relied. Your Lordship would be pleased to find out, Malad, in case of a Navina cinema, at page 11, EIR 56, Calcutta, non-known pictures versus art pictures. Lordship may direct notice, but Lordship, if Malad keeps it on any Malad daily list, Malad, so that decide this point, Malad, that's if something, Malad, is only because of the fact that the suit is dismissed. Where are all on a Malad?
I'm not on that, Mr. Basu.
Malad,
I'm telling you.
I understand, Malad. So for the
refusal,
urgency.
you go before the court, learned first appellate court. After objections, it can be decided. This is also not a case where ad interim was refused.
Yes, Malad, ad interim was refused.
No. Kindly come to second paragraph, last line. Temporary injunction was allowed.
Malad, kindly see the last line. Prayer for ad interim injunction is refused.
Where?
Page 75.
No. In this, the facts of this case, Karnataka
Yes.
judgment.
Yes.
Kindly see paragraph 2. This is the fact.
Yes.
Thereafter, the respondent preferred an appeal under section 96, read with order 41, rule 1. In the appeal, the respondent filed an application for temporary injunction, and since the application came to be allowed, entire application was allowed. It was not an ad interim order.
But prior to that, the suit was dismissed. The injunction was continued.
Not
Suit was
accepting
dismissed.
that, but the question is whether you are entitled to an ad interim order after this lapse of time. Urgency is no longer there.
Very, Malad, then may I only beseech the Lordship, kindly, Malad, Malad, considering all, Malad, and Malad, to best of forgiveness, Malad, whatever may be, kindly give a short date, Malad, I shall come back, Malad. If Lordship, Malad, kindly keeps it on a, Malad, supplementary list. Malad, if it's...
You could wait for 1 year for filing this application.
Malad, kindly.
This is the
Malad,
affectation of your rights
Malad,
by refusal.
Malad,
If you want, I shall record that for refusing to pass an ad interim order.
Malad, kindly do
There are enough grounds, Mr. Basu.
Malad, kindly do not do so.
There are enough grounds. If you
Kindly-
insist on that, prayer for ad interim, I can deal with that and
Malad,
give my reasons.
Malad, kindly, Malad, on its own wisdom, Malad, passes an order for service of notice. I shall come back, Malad, only beseech, Malad, that
Mr. Basu, a senior advocate appearing for the petitioner, submits that though the petitioner was enjoying an order of injunction during the pendency of the suit, which unfortunately got dismissed by a judgment and decree dated such and such, the learned first appellate court, however, refused to pass an ad interim order of injunction in the title appeal arising out of the said judgment and decree. First up, after going through the records, this court finds that the prayer for ad interim injunction in the title appeal was refused on 5th of February 2024. First up, however, the petitioner filed this application under Article 227 of the Constitution of India almost a year thereafter, that is on 31st of January 2025. First up, in view thereof, this court is not inclined to grant any ad interim relief in favor of the petitioner, as the petitioner could not satisfy the urgency involved in this matter. First up, petitioner is directed to serve a copy of this application upon the opposite parties by speed post with acknowledgement due, and file an affidavit of service on the next date. This matter in the monthly list of April 2025.
My lord, judgment
Yes.
and decree dated October 16, 2023.
October 16, 2023.
My lord, liberty to, my lord, pray for, my lord, suitable, my lord, interim order upon service, my lord.
That is why I have mentioned that.
No,
Yes,
kindly record also
I
that.
indicated that for that. Liberty, if you come with an application, we have to consider the grounds. Thereafter, it will be seen. I knew this, that is why I recorded that. Yes, next.
I'm not grateful.
My application.
Yes, Mr. Banerjee.
Needn't be troubled with the papers. I'll just give a brief overview. My suit for divorce against
No caveat.
no caveat. At least I'm told there's no caveat.
Yes,
But my suit for divorce against my wife, Special Marriage Act.
it has to be against your wife.
No, no, that is my suit.
No. Yes,
Section 36 application for pendentility alimony. Admitted facts, she earns 17,000 rupees a month.
what is your income?
40,000 rupees.
What has been allowed?
Allowed is 15,000 rupees a month. Now, for daughter and wife. Now, apparently it seems all right. No, I had also indicated that two aspects your lordship will just consider. One is in the alimony application, there was no prayer for maintenance of the daughter. That's one.
Don't take that technical. After all,
No.
she is your daughter.
Let it be. Two important aspects. One, that she was a business lady. There were Facebook posts, her own declaration when she was admitting her daughter that she is in business, apart from being a teacher. Third, and I think the most important fact that your lordship will kindly consider, is she teaches in this place called Divine Public School. Admittedly, that the food, stay, electricity, and all amenities, including the studies of the daughter, is free of cost.
So, what
So
is the
that-
finding of the learned trial judge? on that?
Nothing on this.
What materials you placed before the learned trial judge?
It is there. Her own, your lordship will just come to page 84 once. This was there before the court below. Kindly come to page 84.
What is
which
the
is-
stage of the suit?
Well, I haven't found out. The written statement has been filed. It will probably be for issues. I haven't found out. But she's filed under 125, and in August 2024, under 125, she gets 6,000 rupees.
125 and this is the
And
different-
no, my only thing is that this should have been considered because everything is free, including food, stay,
What is
electricity.
the
and
finding of the
education.
learned trial judge on that?
Nothing. 84, the document I'm
Show me
told.
that you have raised that. Where have you stated?
Kindly have a look at page 84. This document was before the learned court.
Maybe, but that you have pressed this point. This was argued at the time of hearing.
Well, your
Mr.
lordship will
Banerjee,
come
there
to
may
the
be
improved order.
documents, but you did not choose to rely upon those documents at the time of hearing.
No, my case specifically was that there was
any evidence laid?
Yes, page 84 was before the court.
Page 84.
Page 84. It's not very legible, but your lordship will just see. Well, it is because
84. How do I
84
know
in
that?
Divine Public School is her document.
No, maybe.
And there's an admitted position from her affidavit of asset that she lives here. Your lordship will find position vacant, free facilities provided, food.
You did not
lodging.
raise this point in the time of at the time of hearing. Show me that you have raised this point indicating these documents.
No, well, that The written objection is immediately not on record for some reason. My written objection there, but this evidence was there before the learned court below.
Nobody
It's
knows.
something that
Mr. Banerjee, if the evidence was there, you ought to have pointed out, look, these are the documents, these are his
yes,
income.
that
Show me
argument.
that the trial court, this was pointed out to the learned trial judge and how he has dealt with.
Yes. Your Lordship will turn to the impugned order once.
Yes.
No, the last line of the first page. Third last line. In
Only
case,
finding is that she used to earn 17,000 per month.
yes,
So far as
so
the passbook.
which
So
is
no
why,
other documents was considered by the
which is
learned.
why this order is under challenge. Look, the fact that evidence was there before the learned court below and it does not consider it as a material irregularity.
Yes, yes. Show me the
written objection.
not the written objection, the evidence.
Affidavit of asset, kindly see. The affidavit of asset admits that she lives in this place.
All right, sir.
Page 68.
So are you paying this amount?
Yes, yes. 70, everything arrears, 70,000 I'm paying.
This,
no, they'll have to
no,
come.
this-
I agree
this
that.
15,000, are you paying?
Yes, yes. I'm paying, right? I'm not paying 15. No, the 15 I'm told I'm not paying as yet. Page 66.
So there
kindly.
cannot be any stay of operation of this order. I can direct you to serve.
Yes, ma'am. Kindly.
Us. Mr. Banerjee, learned senior advocate appearing for the petitioner, submits that the
But you are sure
relevant materials
85 was
which
before
were
before the court?
on record before the learned trial judge was not taken into consideration while passing the order impugned. First up, petitioner is directed to serve a copy of this application upon the opposite party by speed post with acknowledgement due and file an affidavit of service on the next date. First up, list this matter in the monthly list of March 2025 under the heading contested application.
Your Lordship will stay this order, no? At least I may only indicate. Your Lordships have
Stay, no.
Your Lordships have held that 1/3 or 1/5 is the thumb
That
rule.
I have to, in their absence, I cannot do
No,
that.
I'm not saying completely state. Lord, 1/5 makes it 12,000 rupees. Lord, I have aging parents. I myself earn 40,000 rupees. I have two parents who are senior citizens who live with me. Their medical records are here. That was also not considered.
What is the amount under the
6,000 is under 125. I'm saying kindly makes it 12,000 for now. That's 1/5 that I'll pay. And gives me the direction to pay that amount. But 17 makes it 12 for now.
তাহলে একটা অর্ডার রেকর্ড করে নিন তো মিস্টার ব্যানার্জি লার্নেড সিনিয়র অ্যাডভোকেটস upon instruction submit
You're not senior advocate.
Mr. Banerjee learned counsel appearing for the petitioner submits that pursuant to the order passed under section 125 of the criminal procedure code, the petitioner is paying a sum of rupees
6,000 per month.
6,000 per month to the opposite
opposite
party
party.
hearing. First up, taking into consideration such fact, now it prima facie appears from the order that the learned trial judge did not take into consideration the amount paid by the amount paid, not the amount which the petitioner is paying under section 125 of the criminal procedure code while passing the impugned order. In view thereof, there shall be an order of stay of operation of the order impugned subject to payment of a sum of rupees 12,000 per month to the wife till the disposal of this application.
Directs me to make the payment, my lord. Otherwise, I'll not pay. Directs me to make that payment.
The petitioner is directed to pay the entire arrears calculated. What is the date of the application? Because
from date of application is not being granted, my lord.
From the date of this order.
From the date of this order.
Mr. Banerjee, you run the risk. If your wife comes up.
If she comes up, I run the risk. It's fair. If she comes up, she'll be entitled to that.
So you are taking that chance.
I have taken the chance, my lord.
To pay the entire areas on at the rate of rupees 12,000 per month as directed by this court. How
From
soon?
December 2024.
Yes, from the date of passing of the order, from the date of passing of the impugned order till the month of February 2025.
Gives me a month, it will be a substantial month. No, it won't be. 12 to 2 weeks.
Within. So by the end of February?
Yes, yes.
By the end of February 2025. It is, however, made clear that failure to make payment as directed by this court will result in automatic vacation of the order of stay.
Very good.
Coming within 5 minutes.
but I should be candid before a lordship, my lord. Was kindly see was 5.
Five.
And last page of the order, bottom.
Yes, last page of the order.
Plaintiff is directed to make deposit of stamp duty in terms of the report additional district sub-register Shialda by memo number 45 dated 15 to 24 on valuation of suit property relating to the suit activity. Only my suit valuation has been mentioned.
Yes.
But which amount has to be deposited not been mentioned. That's why my lord, I have filed an application. My lord, I should point out to the lordship that what is the amount I have to pay. Where is the suit valuation has been only mentioned. But therefore, that applicant has kindly direct the court below to decide the applicant within certain time.
Where is that application?
But day before yesterday, I have filed. Day before yesterday, I have
You have a copy of that application.
copy. Copy I don't have. Kindly give it tomorrow. 2 PM or by this time, we will bring from that. Kindly keep it tomorrow because I was under that impression. Just now I called the counterpart. He said that as the suit value has been mentioned, we filed an application day before yesterday. Okay, what is the amount has to be decided? The area valuation and the suit value.
Valuation, only the valuation report.
They have to be the stamp duty.
Stamp duty they have to assess.
It has not been done.
No application, you have not filed any application before the learned trial judge. Where is that?
But this order was passed rejecting my application as page 12.
Page 12, yes.
I said that in TR form, kindly supply me the TR form so that I can pay the amount.
Mr. Mukherjee, your this application, you have only stated that fix the mode. That means you are aware of the assessment made.
Subsequently, what happened when we came to learn, when we see the memo, because this memo was not known to us, it will reflect from the order sheet. Court said it is my mistake that has not.
No, that is there. But this application, you filed this application thereafter. So you wanted to know.
Before that.
No, you wanted to know only the mode of payment, nothing more than that. It is not your case that I am not aware of the assessment made.
And see once more the date of the application, 12 July.
Yes.
I came to learn about this memo only in my lord 29. My kindly see court himself recorded. Once kindly see once more. First page, last paragraph. I have gone through the case recording.
Also, Mr. Mukherjee, one thing can be done. I am giving you liberty to approach the learned court below for making a fresh application. That will be better. The order dated 29th of November 2024, passed by the learned civil judge, senior division, 4th court at Alipur, in title suit number 677 of 2019, is under challenge in this application under Article 227 of the Constitution of India at the instance of the plaintiff in a suit for specific performance of contract.
It was in 2014.
Specific performance of contract. Mr. Mukherjee, learned advocate appearing for the petitioner, submits that the agreement in question was impounded and the same was sent to the collector 24 Pargana South, collector 24 Pargana South, for making the assessment of the deficit stamp duty. By drawing the attention of the court to the order impugned, Mr. Mukherjee, learned advocate for the petitioner, submits that the petitioner is only aware of the petitioner came to know of the valuation assessed, valuation of the suit property assessed by the additional district sub-registrar Shialda, but the said report is silent with regard to the assessment of the deficit stamp duty. First up, as paid for by Mr. Mukherjee, liberty is granted to the petitioner to make an appropriate application in this regard before the learned trial judge. First up, if such an application is made, the learned trial judge is directed to consider the same and dispose of by passing a reasoned order after giving an opportunity of hearing to the respective parties. With the above observations, CO number such and such stands disposed of. তার উপরে না যেখানে বললাম যে as Mr. Mukherjee submitted that, যেটা বললাম না তার উপরে এটা লিখে দেবেন, in view of the order sought and proposed to be passed, this court is of the view that service of notice upon the opposite parties is not necessary. However, the learned advocate on record of the petitioner shall be obliged to forward a copy of this application along with this order upon the opposite parties or their learned advocates appearing before the learned trial judge. Next.
Extremely grateful.
Lordship, I appear for the petition, my lord. But I must be candid, my lord. I have made this application, my lord. This is actually a request petition, my lord. A request, my lord. If your lordship will kindly direct, my lord, the learned court below, my lord, to, my lord, expeditiously dispose of the suit. A partition suit of 2009, my lord. The issues have not yet been framed, my lord. Even the preliminary decree has not been passed, my lord.
What happened to the application under order for 40 rule 1?
That is still pending, my lord. There was some.
So that has to be disposed of first.
Yes, that your lordship will give, my lord, an order, my lord. The only prayer, my lord, is, my lord, for an expeditious disposal of the suit, my lord.
Ashun. This application under Article 227 of the Constitution of India is at the instance of, you are the plaintiff in the suit.
Plaintiff in the suit, my lord.
Is at the instance of the plaintiff of title suit number 101 of 2009, praying for a direction upon the learned civil judge, senior division at Shialda, to dispose of the said suit expeditiously. From the order sheets appended to the to this application, it appears that an application under Order 40, Rule 1 of the Code of Civil Procedure, dated 4th of November 2009, is still pending, and the date was fixed on 10th of February 2025. So what happened on that date?
The court did not sit.
First up, a written objection was filed.
Yes, well, yes, my lord. Everything is, my lord, the petitions are completed.
The learned advocate appearing for the petitioner submits that on 10th of February 2025, the said application was also not heard. First up,
because the court did not sit.
In the light of the submissions made by the learned advocate for the petitioner, CO number such and such is disposed of by requesting the learned civil judge, senior division, Shialda, to take up the hearing of the application under Order 40, Rule 1 of the Code of Civil Procedure on the next date fixed, and to dispose of the same as expeditiously as possible without granting any unnecessary adjournments to either of the parties. First up, the learned civil judge, senior division Shialda, is further requested to dispose of the suit as expeditiously as possible, as the same is of the year 2009.
If some time frame could be given, my lord. Otherwise, lordship knows, my lord.
No time frame.
Lordship knows much better than me, my lord. Otherwise, what happens, my lord? My
You know much better
No, Lordship.
because recently, where is the order of the Honorable Supreme Court?
Yes, yes, I understand.
So you know better. Yes, next.
Obliged, my lord. Obliged. 17 तो होएगा लोग.
Yes. Look, this is my application. Look, this is my application for expeditious disposal of the injunction hearing, my lord.
Injunction hearing.
Injunction hearing, my lord. It is pending from 2022. I have filed an application. I am for the plaintiff in the learned court below, my lord. I have filed an application. This is a partition suit, my lord. Injunction application filed on 13th May 2022, my lord. Written objection filed, my lord. On the last occasion, written objection filed, my lord.
This is an application under Article 227 of the Constitution of India, praying for expeditious disposal of title suit number 27 of 2022, pending before the learned civil judge, senior division at Shialda. Just a paragraph. The learned advocate appearing for the petitioner, comma, in his usual fairness, comma, submits that though the prayer has been made for expeditious hearing of the suit, but in effect, the petitioner is praying a direction upon the learned trial judge for expeditious disposal of an injunction application which is pending since long. So stop. It is ready for hearing. Objection filed.
Yes, my lord, my lord.
The learned advocate appearing for the petitioner submits that the injunction application is otherwise ready for hearing. What happened on 10th of February?
My lord, they have filed objection on that date and I have took time to file reply. Or my lord, on the next date I shall.
What is the next date fixed?
Next date, my lord, next date আছে 10th February 2020 is the date fixed, but next date is not coming, my lord. 10th February 2025 is the last date, my lord.
In the light of the submissions made by the learned advocate for the petitioner, TO number such and such is disposed of by requesting the learned civil judge, senior division at Shialda, to take up the hearing of the injunction application on the next date fixed and to dispose of the same as expeditiously as possible without granting any unnecessary adjournments to either of the parties. Next.
Plaintiff is the petitioner before your lordship.
Yes.
The order 31, rule 1 and 2 was rejected. Thereafter, miss appeal was filed. It was also rejected. My lord, kindly come to page 75. That is the impugned order of the order 39, rule 1 and 2. Though the deeds was produced before
No, order 39, miss appeal has not been dismissed. Ad interim refused.
Yeah, ad interim refused, my lord. And against that, the plaintiff petitioner before your lordship. There is no reason stated in the order, my lord.
While fighting with the ad interim injunction, file the let the temporary injunction be temporary injunction was disposed of.
Disposed of. The written statement was filed by the defendant number 5 only, and the temporary injunction was disposed of, and thereafter the miscellaneous appeal was filed.
What is the injunction you are praying?
Not to change the nature and character of the land and not to encroach the suit property, my lord. I am claiming the owner of the suit property and I produce the deeds and certain documents, my lord. The defendant number 5 appeared. He never claimed the ownership in his written statement. It was never stated that he is the owner or they are the owner, my lord. They only denied my statements. The impugned order
rejecting the temporary injunction is starting from page 73, my lord.
So I'm directing the miscellaneous appeal to be disposed of within a time frame. Otherwise, it will be kept pending.
No, my lord, keeping kindly in the meanwhile, my lord, just restrain them to make any construction over the suit property.
Temporary injunction has been disposed of by passing cogent reasons.
No, my lord, just may I please, my lord, kindly come
No
to page-
documents, that is the finding. No documents has been
No,
produced
my
by
lord,
you
kindly
to show your title as well as possession.
Yes, my lord, kindly come to page 74, my lord. 74, my lord, that at that the
Have you filed the requisites in the miscellaneous appeal?
Yes, my lord.
What is the stage of the miscellaneous appeal?
It is in ad interim stage, my lord. It was
What ad
refused.
interim stage?
It just refused, my lord, and directed to serve copy upon the.
Have you soft copies? That is what I am asking you.
No, probably no, my lord.
You have not served.
No, my lord. Just the order was refused, and I came before your lordship.
The petitioner has challenged the order refusing the prayer for ad interim injunction by the appellate court in Miss Appeal number 14 of 2024. Full stop. The prayer for ad interim injunction was refused on 18th of September 2024, and the application under Article 227 of the Constitution of India has been filed before this Honorable Court only on 12th of January 2025. First up, in view thereof, there is no urgency for this court to pass any ad interim order at this stage. First up, petitioner is directed to serve a copy of this application upon the opposite parties by registered post with acknowledgement due and file an affidavit of service on the next date. List this matter under the heading contested application with the monthly list of April 2025.
But may I pray for only short that not to construct in the suit property?
Nothing. Yes, next. If they construct, it is found, it will be demolished.
Grateful to your lordship.
Yes.
Lordship, the court below, third court, Howrah, senior division, we had filed a petition for non-prosecution. Now, certain predicament, your lordship, that court is being boycotted for long time. So your lordship may give directions, is pending there. Page 17 is the order. It was just kept with the records.
Yes, you are appearing for the opposite party.
Dependent
Yes.
No, well, let it be disposed of.
Let it be
Disposed of because court is not
disposed of where?
there. Difficulties, court is not, my lord.
What will happen if they chose not to appear?
I have no objection.
So I'm allowing this application from here.
Yes, my lord.
Lordship,
Yes,
lordship.
grateful, my lord.
By the order impugned. No, by the order impugned, particular stage. This application under Article 227 of the Constitution of India is at the instance of the plaintiff and is directed against an order dated 29th of January 2025 passed by the Learned Civil Judge Senior Division Third Court at Howrah in title suit number 194 of 2020. So by the order impugned, the application under order 23 rule 1 read with section 151 of the Code of Civil Procedure along with the affidavit on behalf of the plaintiff has been filed and the same was kept with the record. First up, the learned advocate appearing for the petitioner submits that there's a cease work.
Boycott of
that
the court.
particular court.
That of that particular
That particular court.
submits that the local bar association has adopted a resolution not to appear before the concerned presiding officer. Full stop. Such submission has not been disputed by the learned advocate appearing for the opposite parties. Full stop. After going through the with the consent of the parties, the application under Order 23, Rule 1, read with Section 151 of the Code of Civil Procedure, is taken up for consideration by this court. To stop, it appears from the said application that during the pendency of the suit, at the intervention of some well-wishers and common friends, all the parties to this suit of all the parties to the suit, good senses prevailed upon them, and all the parties have settled their disputes amicably out of court. In view thereof, the petitioner herein filed an application praying for withdrawal of the suit without any leave to file afresh. First up, the learned advocate appearing for the opposite party does not oppose the prayer of the petitioner as indicated in the said application, in the aforesaid application. First up, in view thereof, the application under Order 23, Rule 1, read with Section 151 of the Code of Civil Procedure, is allowed by full stop. The suit stands dismissed as withdrawn without any liberty to the plaintiff to file afresh.
Deeply
The above
obliged.
observations and directions, the CO number such and such stands disposed of.
Registry may be directed to communicate this
Registry is directed to communicate this order to the learned
Third Civil Judge, Senior Division. Civil
Obliged,
Judge,
Judge.
Senior Division, Third Court, House.
Yes, next.
Grateful.
Obliged, Lordship.
My lord, I am appealing on behalf of the plaintiff decree holder, my lord. This is my application for expeditious disposal of the execution case, my lord.
Of the execution case.
Yes, my lord.
What is the decree for?
My lord, decree for the eviction. This is my eviction suit, my lord, and recovery of possession, my lord. I got a decree for
Any
eviction.
case pending? Order
No.
21, Rule 97, Order 21,
No,
Rule
no,
99.
no, my lord. No, my
No
lord.
case pending.
No, my lord. Only their application is pending. Only the defendant judgment debtor one, they have filed one application.
What is the application?
That is the
for?
application for non-maintainable of this execution case, my lord. This is their application, my lord. And they are praying unnecessary adjournment.
This is an application praying for a direction upon the Learned Civil Judge Senior Division at Alipur to dispose of the title execution case number 71 of 2023 expeditiously. So, sir, on a query of the court, the learned advocate appearing for the petitioner submits that no miscase arising out of the said title execution case is pending. So, sir, she however submits that the judgment debtor have raised an objection as to the maintainability of the execution case. First up, it appears from the order dated 12th of December 2024 that the petition dated 19th of April 2024 was taken up for hearing on that date, and the next date was fixed on 24th of January 2025. What happened on 24th of January 2025?
The same, my lord. The next date was fixed. Adjournment allowed.
What is the next date fixed?
21st of March, my lord. 21st of March.
The learned advocate for the petitioner further submits that the hearing of the said petition was adjourned on 24th of January 2025, and the next date has been fixed on 21st of March 2025. In the light of the submissions made by in the light of such submission of the learned advocate for the petitioner, the learned civil judge, Senior Division, Third Court at Alipur, District 24, Parganas North, South, is requested to dispose of the petition dated 19th of April 2024 as expeditiously as possible without granting any unnecessary adjournments to either of the parties. First up, after disposal of the said application as well as all connected applications, the learned civil judge is requested to dispose of the title execution case expeditiously without granting any unnecessary adjournments to either of the parties. Disposed of. Next.
Murder for the petitioner. This is my application under section 24 for transfer of a matrimonial suit malad under section 10 filed by the husband in Kishannagar court. I am praying for transfer to the malad Barakpur court.
Filed by the 24, filed by the husband. Why?
My lord, I am for the
Section
husband.
24 filed by wife
Why?
for transfer of a suit filed by husband.
Transfer of the suit filed by the husband. From where to where?
From malad Kishannagar to malad Barakpur. On the ground, that distance is near about 100 kilometers in one side, and second, the petitioner have two children. One is of 12 years and another is of 8 years, who is under the custody.
What is the stage of the suit?
Well, evidence is going on. WS has
Evidence
been
is going on.
Has been started.
At this stage,
difficulties.
For last 2
Three
years.
proceedings are going on in Barakpur court. One filed by the husband under guardian and ward sec for the custody of the children. One is the maintenance application. Another is my domestic violence application. All are pending in the Barakpur court. Only this suit is pending in
I
Kishannagar.
appreciate that, but you have approached very late. Since it is at the
That is the
evidence stage, it will delay your suit.
Difficulty is that, but the wife have not get any maintenance. It become very difficult for her to attend.
Not
every-
getting maintenance.
No order is passed yet. My lord, no
File an
communication
application
is
for
there
maintenance that is pending.
that the
Your
maintenance.
application for maintenance is pending.
In the-
I can direct that to be disposed of. Section 24 at the evidence stage.
No, the
Evidence has
suit for
started.
guardianship act, it has been dismissed, my lord. It has not. They are not taking steps.
That is the
husband yes, ma'am.
Prayer for vacating ex parte.
Hello, ex parte has been vacated.
3rd of July 2024 was for parentary hearing. What happened? Exhibits. Whose evidence is going on?
Well, the husband,
PW1 closed.
well, the husband's evidence is going on.
Husband's evidence is going on.
It is next date is fixed for the cross examination of the husband.
So cross-examination of by the wife.
By the
Ashun.
actually, my lord, the
Where is
son
the
and daughter is suffering actually. Son and daughter is suffering. They are one is my lord, 12 years, another is 8 years.
but
There
at
is
this
nobody
stage
to
the
look
suit will be
after.
delayed. I can direct this
Lordship
to
can-
be
well,
disposed
one
of.
prayer, may I make one prayer? Lordship can transfer with a direction to expedite the suit.
Well, that will take time, my lord.
Transfer, it will take time. So I will direct them. You will appear only on one day. Your evidence will be taken on consecutive dates. Evidence, if no consecutive dates may be difficult for you.
Difficult for me to I have to travel to the long distance.
So long you have traveled from 2023.
That is true.
Yes, when you have filed that application under section 24.
That section 24 application I have the maintenance application is pending. That is filed under section 180 144 of the my lord BNSS.
BNSS, that is a different thing. Here you have not filed any
No,
application.
That application I have annexed.
This application.
That application is at
section
page
24 of the Code of Civil Procedure is at the instance of the wife praying for transfer of the matrimonial suit number 121 of 2023 pending before the learned additional district judge, first track court, third court at Krishnanagar, district Nodia. to the Court of the Learned Additional District Judge at Barakpur. Full stop. It has been stated in the said application that are you employed?
No.
You are not employed. কি বললাম? It is difficult for the petitioner to attend the court of the Learned Additional District Judge, Third Court at Krishnanagar, as you have two children.
Two children.
As the petitioner has two minor children who are studying in school. First up, it has been further stated in the said application that it is it has been further stated in the said application that the petitioner has to bear huge traveling expenses for attending the court at Krishnanagar. First up. Yes, madam, ask your client to pay traveling expenses. This has to be paid.
I'm ready to pay.
First up. The
My lord, by the option, if they choose to go by car regularly, my lord, that may be difficult.
all right, then I am transferring it. All the proceedings are there.
He is working in USA.
Then I will transfer it.
No, my lord.
All the proceedings are at.
No, my lord, I will pay.
Now you are agreeable. Yes. Thank you.
Husband is working in USA.
No, my lord, now he is in India. He is in India, my lord.
At one point of time, he was in USA.
Both of them are in.
So you have to arrange for a car.
He is working in USA.
You know? First up, paragraph. It is not in dispute that it is not in dispute. The order sheet in connection with the matrimonial suit number 121 of 2023 has been appended to this application. First up, it appears therefrom that the suit is at the matured stage. First up, the examination in chief of PW1 has been completed, and a date. So cross-examination was also done. It was fixed on 25th of September 2024.
Cross-examination has not yet been over. And the next date is fixed for the further cross-examination.
What is the next date fixed?
7th of May.
7th of May.
7th of March?
May.
So on 25th, cross-examination was done to some extent.
To some extent. Thereafter, it was.
And 25th of September 2024 was fixed for cross-examination of PW1. First up, it has been uniformly submitted by the learned advocates for the respective parties that the cross-examination of PW1 was conducted in part on the said date, and the next date has been fixed on 7th of May 2025 for further cross-examination of PW1. First up, since the suit is at the matured stage, this court is not inclined to entertain the prayer for transfer, as the same would result in delaying the disposal of the matrimonial suit. First up, however, the learned advocate appearing for the husband, upon instructions, has volunteered to pay the traveling expenses for the traveling expenses to the wife on the dates she would be attending the court in connection with the matrimonial suit number 121 of 2023. First up, the petitioner will be at liberty to raise bills on account of reasonable traveling expenses for attending the matrimonial suit at Krishnanagar, and if such bill is raised, the opposite party herein shall pay the same. This amount on account of traveling expenses is over and above the amount of maintenance which the opposite party may have been paying to the petitioner in connection with any proceedings.
No such intimation is to us, my lord. Any maintenance has been filed.
That
Till
I have
today
annexed.
No
That I have-
intimation is there, my lord. Any
No,
maintenance
may have been
has been
paid.
filed.
I have not said is paying. You know, first up. You are not paying any maintenance.
No such
তাহলে ওটাকে ওভার এন্ড অ্যাবাভটা লেখার দরকার নেই। দিস কি বললাম? Is only for the purpose of enabling the wife to attend the Krishnanagar court in connection with the matrimonial suit. First up, with the above observations and directions,
Kindly expedite the suit.
disposed of তার আগে লিখুন the learned additional district judge first track court number 3 Krishnanagar Nodia is requested to dispose of the matrimonial suit number 121 of 2023 as expeditiously as possible, but preferably by the end of September 2025. Without granting any unnecessary adjournments, বলেছি?
I'm good.
Yes, next.
My lord, I beg to appear for the petition. Lord, this is an application against the order dated 30th January 2025, passed by the learned trial judge. The issue is that one suit was filed for declaration and injunction. Admittedly, the property is a Thika property by the plaintiff. The petitioners before your lordship is the defendant number 3 and 4. One application, 4 and 5. One application under Order 7, Rule 11 was preferred before this honorable court on a different footing that previously this suit was dismissed for default.
Suit is at the stage of evidence. Issue has been framed.
Issue has been framed.
Maintainability is also an issue.
My
It
lord.
will be decided and directing the suit. to be-
Since this is a very old suit, let it be expedited, my lord. That's my humble prayer.
This is the only suit pending of the year 2005.
No, my lord. This is the only.
Ashok. This application is at the instance of the defendant and is directed against an order dated 30th of January 2025, passed by the learned civil judge, Junior Division, Second Court at Alipur in title suit number 214 of 2005. First up, by the order impugned, the application under section 21 of the West Bengal Thika Tenancy within bracket Acquisition and Regulation bracket closed Act 2001 was stood rejected. First of the learned advocate appearing for the petitioner submits that the suit property is a Thika property and therefore, the instant suit is not maintainable before the civil court. Full stop. It is not in dispute that an application under Order 7, Rule 11 of the Code of Civil Procedure for rejection of the plaint was rejected, and the matter was carried before this Honorable Court in CO number 3945 of 2022. Full stop. The civil revision application also stood dismissed. Full stop. Record reveals that the suit is at the stage of recording evidence of the defendant's witness. Full stop. On a query of the court, the learned advocate appearing for the petitioner, in his usual fairness, submits that an issue has already been framed for maintainability of the suit. Full stop. In view thereof, this court is of the considered view that the learned trial judge was right in holding that the maintainability of the suit will be decided at the time of final disposal of the suit in the form of an issue. Full stop. Paragraph. This court is therefore not inclined to interfere with the order impugned. Full stop. The learned civil judge, Junior Division, Second Court at Alipur, District 24, Pagana South, is however requested to dispose of the suit as expeditiously as possible without granting any unnecessary adjournments to either of the parties. Next.
Grateful, man.
I am for the petition.
Yes, Mr. Mahato.
Defendant number 1 is the petitioner for your lordship in a suit for declaration that the property, suit property at the for declaration that the property is at the owned by the plaintiff. And my lord, I have the defendants have no right title interest over there, and I should not be disturbed the management of this house. Actually, my lord, there was a trust. The settler has died. On the death of the settler, my lord, as per the clause 9.5c, my lord, I being the wife, have my lord become the settler. But my lord, there was dispute between the father-in-law and the sister-in-law. But that dispute was going on, and suit was filed by the father-in-law claiming that he is the ex officio chairman of the college.
Of the college?
Yes. And my lord, my contention.
Governing body of the college? No.
My lord?
Governing body of the college?
No, my lord, according to his plaint, my lord, I have annexed. He says, my lord, Bagnan Teachers Training College having his officer represented by Ataur Rahman.
All right.
Yes. Chairman of the trust.
Trust.
My lord, I taken a point that this suit is not maintainable. However, my lord, the injunction initially was granted in favor of the plaintiff. On contested hearing, it was refused. I was directed to maintain the college. They preferred a misappeal. Misappeal, my lord, allowed. The trial court's order was stayed. A revision petition was filed. In revision petition, my lord, I have annexed the order. If your lordships kindly come to the ordering portion, I have been directed to act as the temporary chairman of the society. It is page 82. My lord, I am reading it. Under these circumstances, impugned order is set aside. Misappeal court order set aside. The order of the learned trial judge is modified to the extent that the petitioner, defendant number 1, and the surviving trustees would comprise a temporary board of trustees to run and manage the college. Till the
Now what happened thereafter?
Well, the Ataur Rahman died. The representative category, who filed the suit, my lord, on behalf of the
Ataur
college.
Rahman, who was he?
He is the father-in-law of the defendant number 1.
Yes.
He filed the suit in representative category.
Yes.
My lord, he has died. My lord, an application for substitution has been filed. That application, my lord, one Muhammad Talib Hossain filed this application claiming that he has been appointed as secretary of the college. Therefore, he should be substituted instead of in place of the Ataur Rahman. I filed the objection. Trial court has said that he cannot be appointed as representative, but I have been directed to hold a meeting and to authorize a person to represent the suit. That can't be. If your lordships kindly come to the impugned order, page 2. First page, my lord, the submission of the parties have been recorded.
Who is the applicant? Who wants to be substituted?
My lord, kindly come to the application. It is at page.
No, who is he?
My lord, he is, my lord, son-in-law of Ataur Rahman. Jamai.
And do you have any relation with the Ataur Rahman? Who are you?
But I am the daughter-in-law. I am the
Oh.
wife of the settler.
You are the daughter-in-law of Ataur Rahman. And son-in-law. So fight between the daughter-in-law and the son-in-law. So fight within the family. Why are you spoiling the college?
Well, college is under the trust. And I have been appointed by this honorable court, my lord, as temporary chairman of the college.
So how are you affected if you call a meeting from amongst
It
the
can't be. It is impossible, my lord. Kindly consider. First is, my lord, a representative category. But that cannot be represented. That is the main point. Therefore, if it is not that, then suit will have it.
So according to you, where is your objection?
My lord, it is at page 87.
87.
Yes, paragraph 13. Plaintiff filed the above mentioned suit as representative of the Bagnan Training College. Thus, the said position has no heritable right. The petitioner is a competent stranger, such as this is the part.
Oh, he is claiming that applicant is claiming to be
He has been
representative of Bagnan Teachers Training College.
Yes. Representative of the representative.
So, but you have taken a point that the substitution application, if it is allowed, will delete the admission of the plaintiff. How can that be?
That is a different thing. But my lord, main thing is, my lord, can it be?
All right, server notice. Yes, the petitioner has challenged the order dated 8th of January 2025, passed by the learned civil judge within bracket junior division, second court Uluberia, in title suit number 405 of 2016, whereby the petitioner was directed to take necessary steps to hold a meeting for appointment of to hold a meeting for the purpose of authorizing a representative on behalf of Dr. Amanullah, Amanulla Foundation. First up, petitioner is directed to serve a copy of this application upon the opposite parties.
Only plaintiff opposite part number 1.
Upon the plaintiff opposite party and file. So plaintiff opposite party means you.
No, I am the defendant number 1.
Defendant number 1. But actually you are representing the college. That means
Yes.
so plaintiff serve upon the opposite parties. Upon the
But
opposite
other
parties.
defendants are not necessary. It may be dispensed with at
But
my risk, man, because they are the
you serve thereafter because
in revision.
the opposite party number 1 is after all you are controlling. You are managing by virtue of the order passed by the coordinate bench. You serve upon the opposite parties and file an affidavit service on the next date. First up, list this matter in the monthly list of March 2025 under the heading motion. Returnable.
Stay of all further proceedings.
There shall be an order of stay of operation of the order impugned till the end of March 2025 or until further orders whichever is earlier. Yes, next.
And I'm appearing on behalf of the petition. A judgment debtor in a suit for recovery of possession, Lordship, is the petitioner before your Lordship. The petitioner has preferred an appeal. Lordship, in the meantime, Lordship, the decree has been put into execution. The petitioner
decree has been put into execution.
An order was
What
passed.
is the title execution case number?
Title execution case number 3 of 2024.
3 of 2024.
Yes, my lord.
Yes.
Thereafter, Lordship.
Now what happened?
Before the appellate court, Lordship, the plaintiff preferred an application under Order 41, Rule 5, praying for stay of
all further proceedings of the execution case.
Yes, that has been rejected, challenging that the petitioner is there before your Lordship.
What is your or what was your status in respect of the suit property?
Lordship, the plaintiff has filed the suit stating me to be a premises, to be a tenant at a monthly rental of 500 rupees.
Nature of the suit property.
Nature of the suit property, it is a 2-room shop room.
Commercial. You are exploiting it for commercial purpose.
Yes, yes.
Where is it situated?
In Boshirhat.
Yes.
In Boshirhat, Lordship, it is a 2-room property.
Occupation charges.
500 rupees per month.
That was the rent, not the occupation charges. I'm asking you occupation charges. That goes with the passing of the degree. Now occupation charges. Commercially exploiting 2 rooms as a shop room.
My lord, I shall just point out
in
from
the heart of Boshirhat.
My lord, heart I do not know. I have been to there once only. It is a Mofusshal town.
If you were briefed by the landlord, you will say heart of Boshirhat. When tenant, no. Yes. How much do you volunteer to pay as occupation charges? I'm asking you. Cannot be an unconditional one.
I understand that.
I'm asking you. You make it a reasonable figure. Otherwise, no interference.
May I just ask my junior to take it?
I'm asking you, not the client.
Not
you are an
client.
officer of the court. You know better. You had conferences with your client.
I met the junior advocate.
So you must have told your client what should be the occupation charges which the court may direct you to pay. These were all the things which were discussed during the conference. So you are aware, no need to take instructions from the client.
Just a figure that might be comfortable.
10,000?
10,000 will be onerous. 5,000? I could have volunteered for 5,000 then. 10,000, Lordship.
That is why I used another expression. Reasonable figure.
Lordship,
It's an unreasonable figure which you are quoting.
It is a small shop room, Lordship. And
what is the measurements of the small shop room? And what is the nature of the business which you are conducting?
Garment shop. Garment shop.
So, all types of garments. During winter, woolen garments, summer, cotton garments.
My lord will kindly not equate a shop room in Bosirhat with a shop room in New Market.
No, not a new market. New market will be not 4-figure.
Even I won't be engaged. Some
5
senior
figure.
advocate would have been
5-figure
there.
minimum.
I
That
wouldn't
is
have
why
been
I have
engaged.
quoted 4-figure.
10,000 is 5 figures. Lord. 10,000 is 5 figures.
6 figures.
বলছেন stay করে দেবে 10. My lord, some amount maybe. I will bow down, but lordship not 10,000, maybe 5,000 or 7,000 lordship. From 500 to 10,000 lordship.
You raise a bit higher, it will come 10,000 from 7. Ashun. By the order impugned, the prayer of the petitioner for stay of all further proceedings. No, it was a prayer was stay of operation of the decree.
Yes, decree has been put into execution there.
Subsequently.
Yes.
আচ্ছা কি বললাম? A stay of operation of the decree was rejected. First up, a decree was passed, an eviction decree. An eviction decree was passed by the learned trial judge on February 29, 2024 in title suit number 93 of 2007. First up, petitioner preferred an appeal being title appeal number 8 of 2024, which is presently pending before the additional district judge, first track, first court, Bosirhat. First up, the learned advocate appearing for the petitioner submits that in the meantime, the decree has been put into execution, being title execution case number 3 of 2024. Tomorrow is the date.
My lord.
Tomorrow is the date.
Today is the date. আজকে 18 তারিখ। Today
is the date for
delivery of possession, lordship.
Delivery of possession.
Yes, kindly takes up annexure.
The learned advocate appearing for the petitioner submits that today, that is আজকে ডেটটা দিয়ে দেবেন, 18th of February 2025 has been fixed for delivery of possession in title execution case number 3 of 2024. Are you sure?
Yes.
No notice was served upon you.
Kindly takes up annexure C at page 48.
Notice was served upon you.
No, we were present, lordship.
You are present.
We had filed a time petition with that we would file an objection, that was refused also.
So why you move this stay application at a belated stage? In order to avoid payment of occupation charges, you are waiting.
My lord will kindly not increase the predicament of the client. My lord is increasing the predicament.
That is why you waited till the last moment, till the writ is issued.
It is better I do not speak anymore. My
Next
lord
up.
will kindly pass.
Paragraph. The learned advocate, first up. The petitioner has a statutory remedy by way of an appeal. First up, if the further proceedings of the execution case is not stayed, the appeal would become infructuous. First up, in view thereof, this court is of the considered view that the executions, that the further proceedings of the execution case is to be stayed. However, taking note of the fact that the petitioner is in occupation of the suit property and is exploiting the same for commercial purpose and exploiting the same for commercial purpose, the petitioner should be directed to pay a reasonable amount on account of occupation charges by way of an interim measure. Full stop. Taking into consideration the extent of the decretal premises as stated in the decree, this court is of the considered view. Now, this court is of the prima facie view that a sum of rupees 10,000 per month as occupation charges would be a reasonable amount to be paid by the petitioner by the opposite party, petitioner to the opposite party herein by way of an interim measure. First up, there shall be an order of stay of all further proceedings in title execution case number 3 of 2024 pending before the learned civil judge, junior division, first court at Boshirhat till the end of March 2025 or until further orders, whichever is earlier, subject to the condition that the petitioner shall deposit occupation charges at the rate of rupees 10,000 per month with effect from the date of the decree passed by the learned trial judge till the month of January 2025 on or before 15th of March 2025. Stop. The petitioner shall be the petitioner shall also pay the occupation charges on and from the month of February 2025 within the 7th day of the succeeding month, till the disposal of this application. Mr. Petitioner is directed to serve a copy of this application upon the opposite party by speed post with acknowledgement due and file an affidavit of service on the next date. List this matter in the month, this matter on কবে বললাম এটা 15th of March বললাম তো পুরো এরিয়াসটা দেবে 15th করবেন না 15th ছুটি আছে by 13th of March because 14th 15th is holiday. 13th of March, list this matter under the heading returnable matters on 17th of March 2025.
Just one prayer, Lordship. The amount Lordship has directed to be paid since the date of the decree.
That is the law.
I understand, but Lordship, can it be in
It
installments?
is, however, made clear that the amount of occupation charges is and has been fixed as a temporary measure, and the final amount shall be fixed after hearing the opposite parties.
Lordship, if it can be done in 2 installments. Because Lordship, the sum would go to somewhere around 1,50,000.
Just now the winter has gone. Winter garments you have earned much.
I'm very
Yes,
grateful.
next. Call the next matter. 26.
To appear on behalf of the petitioner, Your Lordship. Your Lordship, very candidly, I should submit that this is a civil revisional application which has been filed challenging the order impugned dated 9/1/24, which is passed by the Learned Consumer Forum, Bakuda. Your Lordship had apprised me of the fact that there is an provision of an appeal which is pending and the CO shall not be entertainable. Your Lordship, very candidly, I should submit, Your Lordship, that leave be granted to the petitioner to file an appeal. And Your Lordship, also in the meantime, during the pendency of the civil revisional application, Your Lordship, what had happened is that the decree holders had filed execution proceedings, Your Lordship. And Your Lordship, if liberty be granted for us to file an appeal, Your Lordship, they kindly be stay on the execution
No,
proceedings.
my lord,
or
no,
else-
kindly, no, I object
That
to that.
cannot be done.
No,
Your Lordship,
no. You kindly.
File an appeal tomorrow, apply for stay.
Your Lordship, the only difficulty, Your Lordship, here is that this appeal needs to be filed in the circuit bench at Asansol. And also,
That
Your
can be
Lordship,
done.
if
Asansol is not very far away.
Your Lordship, kindly a time period be given and let the execution proceeding be kept in abeyance for the time period, Your Lordship, or else my appeal will
No
remain
time
in.
period, you can file it tomorrow itself. I will give you back the certified copy. The petitioner has challenged an order passed by the District Consumer Dispute Redressal Forum at Bankura in consumer case numbers 27/2022, 45/2023, 46/2023, 64/2023, and 65/2023. First up, the learned advocate appearing for the petitioner submits that through inadvertence, this application under Article 227 has been filed. First up, he prays for leave to withdraw this application with liberty to approach the appropriate forum. Submits the through inadvertence, this application has been filed as the order impugned, as there is a provision of appeal under the Consumer Protection Act. ঠিক আছে, তারপরে ওটা করুন। In the light of the submissions made by the opposite parties are however represented. First up, in the light of the submission made by the learned advocate for the petitioner, leave is granted to the petitioner to withdraw this application with liberty to in the light of the submissions made by the learned advocate for the petitioner, this application stands dismissed as withdrawn with liberty to the petitioner to file an appropriate application before the appropriate forum in accordance with law. First up, the learned advocate on record of the petitioner is permitted to take back the certified copy of the order impugned upon furnishing a photostat copy of the same.
Lordship, just a kind indulgence, Your Lordship. If Your Lordship does not records this as withdrawn, but just disposes of this application granting liberty.
Otherwise, if it is not dismissed as withdrawn, liberty cannot be granted.
Your Lordship.
Yes.
Get full.
Yes.
Yes, next matter.
Next matter.
Yes.
2 p.m. Wait.
Well, defendant's application for rejection of plaint dismissed. But this is not the usual suit, otherwise I wouldn't have troubled your lordship, my lord. Well, there was an ex parte ad interim order of vengeance. Suit is for specific performance of two agreements. Your lordship will see the plaint. One individual is the plaintiff, and two companies are the defendants. If your lordship takes the plaint, before your lordship takes the weight, let me tell your lordship what is it. So, well, the plaintiff, it is the case of the plaintiff that these two agreements, one of 2012 and the other of 2021, was entered into between the plaintiff in his individual capacity and these two companies separately. Now, based on these two agreements, the plaintiff is allegedly entitled to certain rights in a property, which is owned by the company and is being developed by the company. Well, interestingly, in the plaint, they also admit that previously there was a 2011 agreement. There's a reference to a 2011, which is the only genuine agreement. Now, that agreement was between a company and one of the defendants. And this plaintiff was the promoter, director of that company, which actually had an agreement for construction. It was an agreement for construction, land owned by the company, the defendant company, entered into with that company, of which they were the promoter shareholder. And in terms of that 2011 agreement, he is entitled to a share of profit. His entitlement under the 2011 agreement is share of profit. So they make out a case that this 2012 and 2021 agreement, why it was made, they say, this is a plaint case, that in terms of the 2011 agreement, his entitlement was 4 crore 15 lakhs, which the defendant company failed to pay. So they agreed that this 4 crore 15 lakh, which was the entitlement of the company, would be treated as a consideration for another project of the defendant company, that is at Ultodanga. And who would be entitled to that? The plaintiff individually. And then came the 2021 agreement, supplementing the overriding the 2012 agreement. Certain more rights given in property.
Overriding the
2012 agreement. No reference to 2011, because 2000 agreement is with the company and these are individuals. So, prima facie, our case is that both these agreements, 2012 and 2021, are ex facie fraudulent. No cause of action, no right to sue. And my lord, we have also...
Can that be decided in order 7?
Yes, I was expecting that was coming from anybody, but at least this bench. So, my lord, the shift in the Supreme Court, my lord, considering the Dahiben judgment in 2020, and my lord, considering the situation that the present judicial system is passing through, my lord, there is another situation, my lord, where the sham litigations, which is wasting judicial time, meaningless, where, my lord, it is found that the effort, it will bound, the action of the plaintiff will bound to be prove abortive.
Whether it is a fraudulent or not.
Ex facie.
So that has to be
correct
at trial.
That is one aspect.
Can that be proved in Order 7, Rule 11?
So that's why I said, my lord, a manifestly vexatious suit.
That is one thing.
Without a right
to disclose a cause of action.
Correct.
Or a clever drafting. Those line of decisions.
Yes. So what I am
here is a case where you say that this suit has to be dismissed because it's based.
No. I don't say that. We are conscious of that. The moment he is made out, so the
case made out in the plaintiff is such. So fraud I cannot allege right now, though he obtained an ex parte ad interim order of injunction. Vacating application filed, we had the order vacated. In appeal, but they have not been able to succeed in the appeal. A condition was given, not fulfilled. So there's no interim order. So that's the end of the suit. So far as the injunction application is concerned.
Not the end of the suit.
No.
End of
Injunction
the
application.
Yes.
Yes.
Maybe
No, my
if I
lord.
accept your submission, the suit may also be dismissed, but after a full-fledged trial.
Correct. Now, my lord, I am not on the fraud aspect. Your lordship will see. I am on the aspect, this is a manifestly vexatious suit without a right, does not disclose a right to sue, my lord, which is justified within the purview of Order 7, Rule 11 to be rejected. Now, my lord, in order to prove that, I need to show your lordship. And my lord, this is also a case, my lord, where no real cause of action, my lord, can be ascertained from a plain reading of the plain. And my lord, this is a
failure to disclose a cause of action. That is the
illusory
ground
cause of
under Order
action,
7 Rule
nipped in the bud, my lord, in the line of, my lord, that Swami Almananda's judgment, which has been followed in Dahiben. So, my lord, kindly have a look at a few paragraphs of the plaint. The plaint starts from page 9.
Where is your application under Order 7 Rule 11?
Order 7 Rule 11 application at page 310.
So one ground is agreements are ex facie fraudulent
Yes,
documents.
yes, of course. We've
and
made
has
that
never
statement.
been executed. Second ground is barred under section 34.
Right. Then, my lord, kindly take my paragraph 8 and 9.
8 is barred under section 34.
Correct. Then, my lord, kindly take 9. No cause of action. Averments made in the plaint, it would be evident that only a valid agreement made in a plaint is the agreement of 2011 between the pro forma and owner. The entitlement of an incorporated company cannot be an entitlement of an individual, director, or shareholder, since it is not even the case of the plaintiff. Pro forma defendant has assigned or is transferred the 35% entitlement. The entire case sought to be made up by the plaintiff, such and such, does not give any right to the plaintiff, and consequently, the plaintiff has no cause of action for filing the present suit or in sue in his individual capacity.
Yes. So these are the grounds
Yes,
taken.
Then, my lord,
following
10.
the observations of the Honorable Supreme Court, clever drafting,
Yes,
creature
10,
of
10.
fraudulent documents.
Para 10 and also para
10
11.
is borrowing the observations of the Honorable Supreme Court.
Correct. Absolutely.
So basically, the suit is based on fraudulent documents, and one of the grounds is section 34, there is a bar. So these are the true fraudulent documents, and another
Right
thing
to
is, according
sue.
to you, typically real agreement is 2011.
Yes.
2012 and 29 does not give them a right.
No, it
So
doesn't.
whether it gives them a right, one way is according to you fraudulent. So
fraudulent, no.
It goes. So if it is not fraudulent, what right?
Yes.
So suppose these are
If not fraudulent, what right? No, that's what I'm saying.
interpretation of the documents.
No, my lord, does
has
these
to
two?
be-
I'll tell you, lordship, what is happening. My lord, your lordship is conscious of the Maria Margareta Sequeira judgment, that 2012 5 SCC. So, my lord, these are two valuable immovable properties. A complete third party, by creating two fraudulent documents, it is trying to, my lord, encumber the property.
Cannot be injunction dismissed.
Dismissed. Your lordship is aware.
The suit may also be dismissed, but let the suit be decided.
No, my that is where
Issues have been framed.
No. It has not. It's a commercial suit before the commercial court.
You have filed a written statement.
No, my lord, writ of summons has not been served upon us because there is a procedure prescribed under the Commercial Courts Act. So it has to be served in the prescribed form. So it has not been served. So my time to file written
Since your
statement has not
application under
come.
Order 711 is pending. Why it has not been served? Since this application is pending.
No, they have not taken steps.
suit can be dismissed or the plaint can be rejected only on that ground itself. That they have not taken steps, suit can be dismissed on
Well,
that
if
ground.
they have not taken steps for lodging of writ of summons, which has to be served in accordance with the rules of the Commercial Courts Act, it can. But that is also, of course, my additional point.
That cannot be a ground of rejection of claim. Suppose that cannot be under Order 7, Rule 11.
No.
Additional point, you have other recourses.
Yes,
exhaust that.
Yes, I
Nobody
will
is
exhaust
stopping
that. But I will exhaust.
stopping you from that.
Well, I will exhaust that when the right time comes. Well, allow me, well, this is a case, well, which, well, it is a manifestly vexatious suit. Apart from clever drafting, there is nothing. He must have a cause of action, have a right to sue. Just because somebody, now, the interesting part is, I'll tell you, Lordship, well, why we say he doesn't have a right to sue. Even based on the case made out by him, because I proceed on the basis that the averments made in the plaint are true and correct.
Has to be under Order 7, Rule 11.
We are conscious, we proceed on the basis of that. But his 33% entitlement is the entitlement of company. 33% of the share of profit. Now, even if we assume what he said is 4 crore 15 lakh. Now, this, whose entitlement is this company's entitlement? Now, who are you? Now, plaintiff cannot have any right on that 4 crore 15 lakh, which is at best a money claim of the company. Now, interestingly, these two agreements are signed by whom? By his own partner. Now, what had happened is his partner is one gentleman by the name of Vijay Kumar Bhartiya. Now, Vijay Bhartiya and the plaintiff are the promoter directors of the company whom I had given the contract for construction and for the purpose of execution of the project. Now, this same person who is his promoter now, he signs on behalf of the defendant companies. So, it's basically between the left hand and the right hand, the agreements. Fair enough. Now, but even assuming that to be correct,
Company.
it's a company. Now, but the question is that even despite this, if I take the two agreements to be subsisting, to be correct, even then, based on the agreement, he doesn't have a right. So you must have a right to what are they claiming. So, my lord, kindly have a look at some of the paragraphs of the plaint. Lord, the plaint starts from page 9.
Suppose, can you first place the impugned order before going to the plaint?
Impugned order. Lord, in fact, both the applications,
both these applications,
one was the vacating application and the other was the rejection of plaint. They were heard together.
Vacating of the injunction.
And the rejection of plaint were heard together.
Matter of this application.
What I want to bring to your lordship notice is disposed of analogously by a same order.
Yes.
So that's why. So that's why
reasonings is different.
So that's why, my lord.
Only this rejection of
yes, para 16. That would be internal page 6. Internal page 6 of the impugned order, para 16.
So that is the ultimate finding. Show me the observations. Where from it starts? Order 7.
That starts from paragraph 13 onwards. 1-3. There is some interplay between
14. Yes.
Submission.
Yes.
Well, if your lordship starts from 13, for the plaintiff on the other hand submitted that the court at the time of passing of ex parte and thereafter, my lord, so he praised that the rejection of the plaint application, just a few lines thereafter, filed by the defendant 1 and 2 regarding the allegation of fraud, he said they are submitted before the submitted trial without going into the trial stage during authenticity of these two arguments in question. Itself cannot clear that the plaintiff had cause of action to file the instance suit. So as to be paid for rejection of the plaint under application in support of his contention in effort to Lakshmi Cotton Mills. But surprisingly, there's a judgment of Allahabad High Court, Maharashtra Law Journal, Well, thereafter, kindly take 14. So, from the discussion made in the foregoing paragraph, it appears that the present suit has been initiated by the plaintiff in his individual capacity against the defendant number 1 and 2 and one Prangshu Project Private Limited implicated as a pro forma defendant. That is their company. The plaintiff has sought for declaration that the joint venture agreement of 2012 and the supplementary agreement of 2022 be declared valid, binding upon the defendants, and has sought further declaration that the plaintiff is lawfully and contractually entitled to the ownership in respect of the property from the defendant number 2 and 50% of the built up area from the defendant number 1 and consequentially prayer for mandatory injunction. The plaintiff has also sought for specific performance of the two agreements. In the application for injunction, the plaintiff has sought temporary injunction, similar type. Then, my lord, kindly take 15. So, considering all, this court is of the view that in order to arrive at the conclusion regarding the authenticity of those two alleged agreements, as well as the cause of action as averred in the plaint challenged by the defendant, trial is necessary. Without going into trial, nothing could be held at this stage.
So
Therefore,
this is the finding. What is your ground that it is barred under section 34? Why it is barred under section 34?
so, my lord, 34 is a ground which we say, then I have to show your lordship the plain. My lord, he has
No, no.
not.
What is the ground? What relief has been not been paid for, though he ought to have
No,
paid
he
for?
has.
That is section 34.
Yes,
That
yes.
ground. So what
yes,
is the
yes,
relief
yes.
according to you ought to have been paid for by the plaintiff, not paid
So
for?
we have not really, because we say that he has no right to sue.
No. That is one thing. Paragraph 10
Yes,
of your
yes,
application
yes,
says
yes,
barred under
yes.
section 34. Let us proceed one by one.
No, my lord, what we are trying to say is that he is not entitled to a decree for declaration because he doesn't have a right to sue. He must have a legal character
Not
to seek
34.
a declaration.
34, you are not pressing.
No, my lord, 34, what your lordship is saying to say that.
Because that is your section, order 7, rule 11, that is your specific
Yes,
ground
yes,
taken
yes.
in, I think in paragraph 9 or 10.
Yes, there is a ground.
So-
There is a ground.
So can
There
you
is a
show
ground.
what is the relief which they ought to have paid but not paid?
No, there is no such relief that
So
they ought to
section
have paid, they have
34
not paid.
So section 34 is not a bar.
Not a bar. Now, what we are trying to say is that in order to get a declaration under 34, you must have a legal right.
So basically failure to disclose a cause of action.
Correct.
That is what you are trying to.
Absolutely. Failure to disclose a cause of action and he doesn't have a right to sue. For the relief that he claims, it has to be read together. Otherwise, my lord, it will no cause of action, no right to sue. And my lord, this.
So is it not for deciding that trial is necessary?
No, my lord, it is the orthodox view. The classical view is that.
Not a orthodox view, because whether on the basis of the claim or the case made out in the plaint, he is entitled to that relief.
Correct,
For
absolutely.
the entire matter is to be gone into, evidences are to be laid, documents, interpretation of the documents is necessary. So whether in this application, from the statements made in the plaint, can it be
My lord,
said?
prior to
Because one of your ground is fraudulent document.
No, my lord,
That is also eschewed.
Hmm.
That you cannot say raise that plea of fraudulent documents under order 7 to 11. So the scope becomes much limited.
Well, I am not on the fraudulent document right now. I have
34
to.
goes. Fraudulent
I-
document goes.
Correct. I have to accept 2012 and 21 agreement and satisfy the court that based on these two agreements, he doesn't have a right to sue or he doesn't have a cause of action to seek the relief that he claims. Because so well, classically,
Only the difficulty
Yes.
will be if I give any finding that might affect any of the parties. Because I have to hold what right prima facie, what right those agreements give, apart from that fraudulent, whether on that basis he is entitled to that. That has to be an observation.
it has to be. That's what Supreme Court is saying. The court
Yes,
must
so
examine.
that might affect any of the
Yes, it would. I am willing to take that risk. This suit, I am willing to take the risk. I'm willing to take that risk.
Yes.
So, my lord, kindly take the plaint.
Yes.
Now, my lord, now it is, my lord, I need not tell your lordship, my lord, your lordship is well aware plaint with the documents relied upon in the plaint. Plaint along with the documents relied upon by the plaintiff in the plaint. Both requires to be considered at the time of consideration of an application for rejection of plaint.
Have you got that judgment, Mr. Bose,
My
which
lord, I have-
says that documents along with the plaints are to be
Yes,
considered?
yes. The Heben says that.
Yes, I think it's
Yes,
of
the Heben says that.
2007.
Yes.
The judgment is of 2007. Are you carrying that judgment?
Yes, yes. I am carrying 2007-5. That is that Hardeshores. Hardeshores. Yes, I am. I am.
ছিয়াত্তরের জাজমেন্টটা সেটাতে
তুমি তো এলাহাবাদ অন্ধ্রপ্রদেশের সিঙ্গেল বেঞ্চ তো দেখা No, well, I'll give you lordship first that. Well, this is 2007-5 SCC.
No quarrel with that proposition.
Share দেখতে চলেছে।
Yes.
দাদা কি দেখান একটু বলুন?
My lord, in fact, my lord, if your lordship takes the Dahiben judgment, Dahiben takes into consideration this judgment. Dahiben টা আমারটা দাও তো।
দাদা একটু সাইটেশনটা বলে।
This is 2007-5 SCC 614.
Yes. You are relying upon this 2007-5.
Yes, yes. What I was relying upon is Dahiben's judgment, which considers all the previous judgment, which is in
So you
2027
wanted me
SCC.
to look at the plaint first.
Yes, yes, yes. Of course, of course.
You can proceed in your own way.
Yes. Kindly have a look at the plaint first. Your lordship, the plaint starts from page 9.
Page 9.
Yes. Plainটা খুলে রাখো তো। My paragraph may not tally. Your lordship will kindly have a look at the cause title. Plaintiff is an individual. Defendant number 1 is a company. And my lord, interesting, your lordship, kindly have a look at the cause title. Through its director, Vijay Kumar Bhartiya. Then my lord, then Deep Holding is also a defendant company, and then the pro forma defendant, though there's no such coinage, but be that as it may, lord, Prangshu Projects Private Limited has been made another defendant. My lord, now kindly, my lord, come to paragraph 4.
Yes.
Well, that during the course of business, defendant number 1, which happened to be the owner of a portion of land and such, which is the Ultodanga land, had approached the plaintiff through such and Vijay Bhartiya in 2007-8 to join it as real estate agent partner to keep it procuring and developing the land. Has your lordship found that, my lord?
Yes, yes.
Measuring, including negotiating with the owners, land, negotiating with existing occupiers, collecting, scrutinizing land records, such and such. Thereafter, your lordship will kindly take para 5. So based on these deliberations and negotiations, what happens? That pursuant to the detailed deliberation, it was mutually agreed between the plaintiff and the defendant number 1 that they would jointly develop. My lord, kindly make a note. So this is your case. So they would jointly develop a real estate housing project at the land lying at such and such, which is at Ultodanga, in which the plaintiff would take responsibility to negotiate with the owners. And these are the responsibilities of the plaintiff according to them. I need not trouble your lordship. Then, my lord, kindly come to para 7. That with the due effort, intervention and mediation of the plaintiff, the lands were purchased in the name of the defendant number 1 by virtue of separate deeds of conveyances. Man, I am not showing the inconsistencies, but I will just take you because there are glaring inconsistencies in the pleadings. After such purchase, the defendant number 1 became the absolute owner of such and such, including then divided into 4 parts. Now, your lordship will kindly skip that. Now, your lordship will come to para 8.
Yes.
Pertinent to mention here that the lands of the first and the second part had been amalgamated into one premises, such and such, schedule 1, then 101, then kindly take para 9. Before commencement of development work in respect of the Ultodanga project, the plaintiff jointly decided to reduce their agreed terms and conditions in their business deeds into writing. And accordingly, on 8 June 2012, in order to avoid any legal complications to secure and respective obligation, record the respective defendant number 1 had entered into a joint venture bracket service agreement. Thereby, so this service is also equally interesting. So, my lord, I need to show your lordship this agreement. My lord, before I take your lordship to the agreement, allow me to place the plaint first. Then, relevant clauses of the joint venture service agreement, clause 5.3, then 5.4. Some of them set out. Now, kindly come to para 11 at internal page 8 of the plaint. That in terms of the joint venture agreement of June 2012, it was agreed that the plaintiff would develop the Ultodanga project, but not limited to obtaining sanction from the competent authority, demolishing, building such and such. Then, my lord, kindly come towards the end of this paragraph or towards the middle. Allow me to place the whole paragraph. Building, appointment, architect, procurement, such and such, activity, the cost of expense, the defendant number 1, and consideration of service rendered as aforesaid, or cost to be rendered by the plaintiff in the project of the manner, the plaintiff would be entitled to, has your lordship found that, my lord? 33% of the total built up space.
Yes.
Which we have computed in this project, it comes to about 33 crores. So, that's an absurd figure. So, this is his case. 33% of the total built up space in the project, where the defendant would be bound to transfer in favor of the plaintiff and not his nominee. It was agreed that the balance 65, 70, 67% of the total built up space will be retained by the defendant number 1. And your lordship will see what will he do under the agreement. Your lordship has seen what is his services to be rendered under the agreement. He's already said that in paragraph 4 and 5, he will do due diligence, collect, negotiate. For that, he'll get 33%. Now, my lord, kindly allow me to place paragraph 12. My lord, kindly allow me to place this. Para 12, he says, kindly come back to para 12, my son. After 11, he says 33% he is entitled to in the Ultodanga project. Now he says, pursuant to the 2012 agreement, the plaintiff took endeavor to develop the said property and also obtain necessary building sanction plan and approved by Kolkata Municipal Corporation such and such as mentioned in such and such. Then, that apart from the facts stated above, it is relevant to mention here that the plaintiff and the defendant number 2 were also working together. It was not defendant number 2. Also working together in a different real estate project, which is Dom project, in the same model, in the same project, and had entered into a memorandum of understanding of 22nd of October 2011 with pro forma defendant. So the agreement is a part of the plaint. Now, my lord, kindly make a note of this. Where the defendant number 2 had engaged the pro forma defendant to render certain services and work upon development of a real estate project and such on stipulation and covenant and envisaged therein. Pertinent to mention here that the pro forma defendant was jointly created at the instance and at the behest of such and such and such and such.
Yes.
Whereby the plaintiff was also a director out of the cordial relationship between them to ensure effective supervision of the project. It was agreed that in consideration of the said services of the pro forma defendant, the defendant number 2 would part with 33% of the profit in favor of the pro forma defendant at the end of the project, and the balance 67 to be retained by it. So, well, the profit sharing ratio is admitted in the plaint. So under the 2011 agreement, and who gets the profit? The company, which is the pro forma defendant company. Now, so this is made a part of the plaint. MOU annexed. Then, in terms of the MOU of 2011, para 14, plaintiff independently rendered the services. Plaintiff independently rendered the services, as mentioned therein in respect of the Dam project, without any complaint whatsoever, and successfully completed the building and discharged his part of the duties in such and such. And after completion of the project, disputes, anomalies cropped up in and around November 2019 between the plaintiff and the defendant number 2 with regard to settlement of accounts in respect of the said project. However, thereafter, with the intervention of well-wishers such and such themselves by virtue of the memo of settlement of supplement agreement of 2021. So 2021 is settlement of the 2011 agreement. So this is his case. So 21 agreement also forms part of the plaint. During the course of settlement dispute Dam project, the my lord kindly take my lord para 15. During the course of settlement, the disputes of the Dam project were finally settled between the parties, and it was mutually agreed, inasmuch as the plaintiff alone and independently has rendered the entire services under the project, the share payable to the pro forma defendant would be transferred to the account of the plaintiff.
Yes.
Should be transferred to the account of the plaintiff instead of the pro forma defendant. Is the lordship found that, my lord?
Yes, yes.
Not permissible in law. So his right to sue arises out of this. Pursuant to such decision, it was mutually agreed after settlement of accounts that the plaintiff would be entitled to a consolidated sum of 4 crore 15 lakhs. Plaintiff would be entitled to, together with the flat, including a car parking space at Dam project, and a full and final settlement of the plaintiff under the memorandum of understanding in the manner they agreed, such and such Dam project. In such context, pro forma agreement cease to have any claim or demand against the defendant under the MOU with respect to this. That pursuant to the detailed deliberation, mutual consideration of the party, defendant number 2, mutually settled between all the parties hereto, that a sum of 4 crore 15 payable to the plaintiff shall be deemed to be the investment of the plaintiff in the Ultodanga project.
Yes.
And in lieu thereof, the plaintiff shall be provided with an extra allocation of 17% of the total built-up space in Ultodanga project, in addition to the existing allocation of 33%, to 50% of the total project area. As far as the said flat is concerned, it is agreed that a self-contained flat, then he proceeds, then my lord. Then kindly come to a few sentences thereafter, it's starting with, in pursuance to the said agreement, the defendant number 2 had delivered possession of the flat to the plaintiff, and also undertaken to transfer and alienate the said flat or his nominated person such and such. It was further agreed and made incumbent that the plaintiff and memo of such and settlement to executed by such and such. Then the memo of settlement and supplementary agreement 21 was agreed that the settlement amount of 4 crore 15 lakh would be treated as an investment made by the plaintiff in the Ultodanga project and deemed to have been utilized in the said project in lieu of the investment. The plaintiff would get an additional same repetition, my lord. Then 2021 agreement referred, some of the clauses referred. Then para 19 at page 14. Well, this is an interesting paragraph. That pursuant to the supplementary agreement of 2021,
yes,
the plaintiff with all sagacious spirit and attitude started work, remaining development 1 in respect of such and such, discharge his obligation on the settlement agreement. However, soon after the registration of the conveyance deed, disputes and anomalies cropped up between plaintiff and the defendant number 1 from January 2022. when the defendant number 1 all of a sudden started evincing a spirit of declination to spend any further money in the Ultodanga project on the pretext of losses suffered during the pandemic. On the contrary, defendant number 1 wanted the plaintiff to make some more investment in the project. However, when the plaintiff refused to make any further investment, or raise any other unauthorized float, he will be doubted with the intention. The my lord, pausing up for a moment, my lord, there is not one word anywhere that he has invested even 1 rupee in any of the projects. Nowhere. He says that the 404 crore 15
will be an
lakh
investment.
that will be treated,
As an investment.
entitlement of the company, the pro forma defendant company would be treated as an investment in the Ultodanga project, even assuming, but in whose name? In the plaintiff's individual. Nothing mentioned that any board resolution plus any agreement that this Prangshu projects, which is the pro forma defendant, was also a party. So, so I could have said that there is a element of novation of the previous contract where my entitlement, I like a garnishee proceeding, you give it to the third party. Nothing. Then, my lord, if your lordship will kindly take para 20, such disdainful and unethical act on the part of the defendant has tainted the sense of doubt and insecurity, and that the defendants might cheat and hoodwink him from the rights and benefits vested upon him under the settled agreement of 2021. Finding no other alternative, plaintiff had paused development work in the suit A property and requested the event to first settle the accounts and disclose the books of accounts. Then, my lord, kindly come to paragraph 22. That meanwhile, the plaintiff further came to know through the local real estate brokers that the defendant number 1 has been surreptitiously trying to transfer some flats of the said building being constructed in lot 2 without the knowledge of the plaintiff. The plaintiff, having come to know of the same, immediately conducted online search from the office of the West Bengal registration on 11th of April 2022, when, to his utter shock and surprise, he came to know that the defendant number 1 has transferred a flat in the building in favor of a buyer by virtue of a deed of conveyance of 31st January 2022, registered in the office of such and such, a certified copy whereof has been obtained through the online portal of West Bengal registration by paying prescribed fee, annexed. So, my lord, this document is also annexed.
Yes.
Then, my lord, I'll show you, my lord. Now, the cause of action paragraph, para 23. So, my lord, he says that the plaintiff said, despite giving assurance of settlement, D1 surreptitiously transferred the flat in gross violation of the Joint Sector Act 2012 executed by the plaintiff. Flat triggered a reasonable apprehension in the mind of the plaintiff that the defendant number 2 might sell off the B scheduled property to third party interest in respect of such and such. The worst has been compounded on 20th April, when men and agents of the defendant number 1 unlawfully restrained the plaintiff from entering into a suit property, creating a huge chaos, then addressed a legal notice, then suit. Now, my lord, I'll just show your lordship the agreements. My lord, kindly take the first agreement of 2011 first. My lord, kindly take the 2011 first, which is at page 223. আমার এখানে 2011 এগ্রিমেন্টে কোথায় আছে একবার দেখে নিই তো, দাঁড়াও। এইটাতে কাইন্ডলি গিভ মি আ মোমেন্ট ম্যানার। এইটাতে আমার কোথায় আছে? আছে প্যারা, কোন প্যারা ছিল 2011 এগ্রিমেন্টটা? Yes, this is annexed as 176. I got it. No, I marked here, no? Yes, panel. You tell me the page number. But kindly, this is page, just keep this open. Kindly come to page 223. This is the agreement which is genuine agreement between the defendant number 1, and your lordship will see deep holding, which is the defendant number 1.
223.
Yes. Defendant number 2 and 3. Pro forma defendant company. Your lordship will see two things here. Well, in the recital where the deep holding name is there, which is the defendant number 2, your lordship will see where the address is there immediately below the address. By virtue of a board resolution, my lord, the person who is the director, his name is there in the third, represented by the chairman come managing director such and such. Thereafter, by virtue of a board resolution dated such and such. So without board resolution, you cannot transfer or deal with properties of a company. My lord, Companies Act prescribes that. Now, if your lordship will interestingly turn to the next page, Prangshu. In 2011, this naturally could not have come to their mind. A private limited company incorporated under such and such, registered such and such, represented by its director Vijay Kumar Bhartiya, sum of such and such, by occupation such as number 2, Balaram Paja, which is the plaintiff.
Yes.
Now, my lord, your lordship will kindly come to my lord 178. I stand corrected, my lord. Page 225, clause 2. Supervisory control. So this is the scope of the agreement. Then, my lord, what they get is at page 227, absolutely bottom of page 227, clause 6, right of party in second part.
Yes.
Your lordship will find that the party of the second part, which is the pro forma defendant, is entitled to 33% of the provisional profit after tax account of this project.
Yes.
So his entitlement is there. Now, my lord, interestingly, kindly come to the 2012 agreement. 2012 agreement is at page 203. আমার এখানে কোথায় আছে 2012 agreement ওর আগে আছে না? Yes, this is the 2000. Yes, I'll kindly come to page 203. My lord, interesting, my lord. Kindly see T.N. Gupta, which is D1.
Mr. Bose, how long you will take? Because
I can
hard finally,
no.
it's a motion bench, then
I
have to fix the date for hearing.
Correct.
Because if you
No.
place comprehensively all the agreements and other things,
Otherwise,
it has
well, I
to
will
be-
not be able to prove that.
then I can fix it for hearing
Any day.
of the revision
Hey,
application. There's no scope for any stay to be passed.
This suit will
Let the
proceed.
suit proceed, nothing will happen. You may have the suit dismissed. Because after all, if it is to be hard, it is to be hard at length.
Not a suit of this nature. This is a suit which is
Suppose, so long you have taken time, you will have to place all the agreements. So it is to be hard.
No, because-
unless all the agreements are to be gone into all the clauses, what is the effect of the clauses?
No, because
vis-a-vis these three agreements.
right to sue, because right to sue
So
and cause of
in that,
action.
it has to be so. It is to be hard.
Yes,
extensively.
it has to be heard. No doubt about that. No doubt.
Ashok. The petitioner has challenged an order rejecting an application under Order 7, Rule 11 of the Code of Civil Procedure. Mr. Bose, learned senior advocate appearing for the party, submits that the application for rejection of claim was dismissed by a non-speaking order. First up, he submits that the plaintiff has failed to disclose the cause of action to support the ultimate relief claimed in the suit. First up, after hearing the learned advocate for the parties, this court is of the view that the matter is to be heard at length. First up, Mr. Banerjee, learned advocate, appears for the opposite parties. First up,
I appear for the opposite party.
one opposite party.
Well, the plaintiff. Well, the other
For
opposite
the-
parties.
For the plaintiff opposite party.
Number one.
First up, number one. First up, list this matter under the heading contested application in the monthly list of March 2025.
And will not pendency
May I
of
have your-
this application would not be an
Pendency of this application shall not be a bar in proceeding with the suit before the learned
And will
trial
not-
judge.
it has gone down in my lord's order that my learned senior friend's contention is that there is no disclosure of cause of action.
Failure to disclose cause of action, that is his
My
argument.
lord, Order 7 Rule 11 says plaintiff has no cause of action. Doesn't say plaintiff does not disclose a cause of action.
It says both. It says both.
plaintiff
Paragraph
has no
two
cause of
different
action.
things.
And
But
I
that
also
is
say
submission.
manifestly a
Submission
vexatious.
is that there has been a failure to disclose cause of
There
action.
is a gulf of difference, my lord, between these two.
Yes, yes.
No, we have said both. Plaintiff has no cause of action and the plaintiff discloses none.
পড়ে দেখো para 9 টা পড়ে দেখো and para 11.
Where it does not disclose a cause of action.
Yes. But he can't say I do not have a cause of action.
No, failure to disclose a cause of action. That is his submission. I think I have
That's
recorded
not
that.
the case in the Demerara
Right, na?
application.
That is
Failure to
exactly
disclose-
the case in the Demerara.
Failure to disclose a cause of action.
That has gone down, but no, that's not his case in the Demerara application. I will come.
That you can make it. That is his submission. কি বলছি?
Ready.
Failure.
Submits that the plaintiff has failed to disclose the cause of action.
Plaintiff has failed to disclose the cause of action.
Grateful.
Yes, next.
Right. Grateful. No, my lord, the Thursday is the next date fixed before the trial court is Thursday.
Let it proceed, Mr. Post. It will help you. If it proceeds, you can take your available other recourses before the learned court trial judge. Can have the suit dismissed because Mr.
My
Banerjee's
learned
client
senior
is not
friend knows,
taking,
my lord, that recourse is
uh,
not available to him.
is not taking steps, or if in the meantime,
Yes, yes. Oh, but
let it proceed both
Commercial
ways.
suits, my lord, Order 39 Rule 3 is complied with, that recourse is no more available.
Yes, call the next matter.
Good.
I'm appearing on behalf of the petitioner lordship led by my senior advocate Mala Bhattacharya. Lordship, this is my application seeking transfer of proceedings of matrimonial suit 664 of 2020 pending before the learned district and sessions judge Barashat lordship. Lordship, the marriage was solemnized between the petitioner and the opposite party number 2, that is the husband lordship, in the year 2015.
What is the stage of the suit?
Lordship, now argument is going.
Argument.
Yes, stage of argument is going, lordship.
So what is there now?
But it is going on ex parte lordship, and I have been financially not so well to travel.
Argument stage cannot be transferred.
Lordship, there is a specific ruling of the Honorable Supreme Court lordship. It's mentioned in paragraph number 9 and 10. It's specifically mentioned here, lordship. Kindly consider the paragraph number 9, lordship. It is written here. The cardinal principle of exercise of power under section 24 of the Code of Civil Procedure is that the ends of justice should demand the transfer of the suit, appeal, or other proceedings. In matrimonial matters, wherever courts are called upon to consider the plea of transfer, the courts have to take into consideration the economic soundness of both the parties, the social strata of these spouses, and their behavioral patterns, their standard of life prior to the marriage and subsequent thereto, and the circumstances of both the parties in eking out their livelihood and under whose protective umbrella they are seeking their sustenance to life. Given the prevailing socio-economic paradigm, in the Indian society, generally, it is the wife's convenience which must be looked at while considering the transfer. In my case, Lordship, I am getting no maintenance, and I have to specifically I have to travel around 6 hours in one way, Lordship, from Galsi to Barashat, Lordship, and this is actual hardship to me, Lordship. And Lordship, and there is another proceedings is pending which I have been filed for 125 maintenance proceedings, Lordship, which is pending at Bardhaman, and the husband has to travel to attend that proceedings also, Lordship. So and Lordship, if Lordship, where in Kolkata, where the husband is residing, from there to come at Bardhaman, it is quite easier for him than me to come from Galsi to attend the court at Barashat, Lordship.
What is the date fixed for argument?
The next date is 21st of February.
The matter will be transferred since the family court has been, my lord, enacted, my lord, in all the districts, my lord. Now the matter is pending before the ADJ, my lord. Ultimately, the
It
matter
doesn't fix for argument. What is the date fixed for argument?
21st.
21st of February.
21st, my lord. Well, the matter will be transferred ultimately. On that day, my lord, the argument will not take place, my lord.
All right, I'm directing this matter to be placed in the monthly list of March. Let us see what happens.
By this time, my lord.
Argument, no.
My lord, by this time, my lord, kindly pass an order of stay, my lord.
No. Argument, no stay.
My lord,
This is not at the stage of argument.
my lord, even if, my lord,
Then I can dispose of this application. If you want, I can dispose of this application. I will consider this decision and I will pass
by
orders.
showing your lordship, so my lord, kindly take a chance, my lord, kindly fix the matter, my lord. My lord, what happened, my lord, on the last occasion when the Mr. Justice, my lord, Basu, my lord, directed to serve copy, my lord. Although, my lord, in the plain address, I have served the copy upon the husband, my lord. It has been refund back with the endorsement. The address cannot be located, my lord.
Then not.
But in
Service
view of,
is not
my lord,
complete.
in view of the, my lord, plain's address, my lord.
Maybe.
My lord, kindly see, my lord, kindly.
If the service is not complete, the matter cannot be decided. Ashun, every service filed
With this observation, my lord, kindly, my lord, direct, my lord,
what?
to serve once again and kindly fix
That
the
can
matter
be done.
any date, my lord.
File your affidavit service.
Yes.
Affidavit service filed in court today is taken on record.
And the same address, my lord, as written in the plain, my lord.
Said affidavit of service that the where have you stated that it has
Affidavit service ligature. My lord, the endorsement.
no, you have not stated anything in the body of the
address, my lord, the envelope is, my lord, with me, my lord. That is address cannot be located, my lord.
Where it has been stated that the address cannot be located.
Well, the
item delivered to the sender.
My lord, that
So
means
where
it has been returned to me, my lord. Senders been returned to me.
Yes. You have not annexed that. That should have
No,
also.
no, I have not annexed.
From the said affidavit of service, it appears that the registered article was delivered to the sender, that is to the petitioner herein. First of the Mr. Bhattacharya, learned advocate, appealing for the petitioner submits that the registered envelope returned with the endorsement at within inverted comma addressee cannot be located. Therefore, the service cannot be said to be a good service. First up, in view thereof, petitioner is directed to serve a copy of this application afresh upon the opposite parties by speed post with acknowledgement due. First up, the petitioner is further directed to serve a copy of this application upon the learned advocate representing the opposite party before the learned trial judge. First up, the petitioner shall file an affidavit of service on the returnable date. Establish this matter in the monthly list of March 2025.
Instead of monthly, my lord,
No, monthly is the matter.
Monthlies will be published only.
Published, but the matter cannot be.
Yes, yes. Next. So Bhattacharya appear there, otherwise ex parte.
But that is the problem, Milord. Milord, kindly consider the situation of this particular persons, Milord. Well, if you also kindly pass a very short stay, Milord.
Order was passed, so wrongly it is appearing. It has been pointed out that this application, that this civil revision application was disposed of by an order dated 17th of February 2025. So, in view thereof, no further order is required to be passed. Next.
Lordship, kindly give me a short passover, please. Short passover.
Why? Who is appearing?
Mr. Orijit Bardhan. I am led by Mr. Orijit
Bardhan.
Huh.
Start. You start.
Lordship, kindly give me a short passover. Kindly.
Start. You are his junior.
Yes, but Lordship.
Yes. You have read the brief.
No.
You have not read the brief. Place the impugned order. Do you know where the impugned order is?
Yes.
Yes. Last document of, you don't have the copy.
No, sir. Lordship, kindly give me a short passover.
All right. Passover.
Wait, please, your lordship. I'm for the applicant. My lord, this is a section 24 matter. My lord, this is the affidavit of service.
Yes.
My lord, the last order was passed on 8th of August 2024. This is for the transfer of a matrimonial suit from Durgapur Court, the additional district judge at Durgapur, to Alipur, the district judge at Alipur.
Where are you residing?
My lord, I am presently residing at the last known place at Sonarpur, but my lord, I'm praying for it at Alipur because I am just a sales girl at Quest Mall. It would be easier for me to traverse between the two places at Alipur Court.
One thing is, my lord, that but prior to that, in 2016, my lord, petitioner, my lord, filed one DV Act, my lord, at Baripur, my lord.
Filed a?
DV Act, my lord, at
Yes.
Baripur, my lord. Thereafter, my lord, when I filed this, my lord, matrimonial suit before the Durgapur, my lord, subsequently he filed 125 at Alipur, my lord.
125 at Alipur.
Alipur, my lord. Subsequently change his address, my lord, to harass me, my lord. With 3 courts, my lord, I have to round over the 3 courts.
Address
my
change.
So now you have to contest the 125 at Alipur. So it's better if it is transferred, all the proceedings will be at Alipur.
One thing is that, my lord, for troubling me, my lord, because I have to adduce my evidence, my lord, regarding on 13, my lord. So bring the all evidence, my lord, person to the court, my lord. It may be middle portion. I am not against the transfer.
Middle portion will cause difficult because the other proceedings are there. There is a judgment of the Honorable Supreme Court which says, so you are aware of that. So that is why I indicated since 125 is pending. Without mentioning that proposition, you said no.
Baripur, my lord, that also, my lord, I have to also travel the Baripur, my lord.
So Alipur will be nearer rather than Baripur.
My lord, that's.
Uh,
Just record my formal objection.
No. I will record your objection. It's not on consent. This application under section 24 of the Code of Civil Procedure is at the instance of the wife praying for transfer of the matrimonial suit number 107 of 2023, presently pending before the learned additional district judge at Durgapur to the learned district judge at Alipur.
Lordship, I am interrupting once. The application has been corrected. It is matrimonial suit 302 of 2023.
302.
because 107 was the registry number. The suit
The
number,
cost title says 107.
my lord, the
cost title.
prayer portion,
Cost title you have not corrected.
lordship, I apologize. I take it on me. My lord, I take it on me.
Prayer also not corrected. First paragraph not corrected.
My lord, I will pay for it. This, if the cost is upon me.
Leave was obtained.
Lordship. Lordship.
Nakiola. The matrimonial suit number ta ভুল হচ্ছে তাহলে ওটা হবে 302 of 2023 presently pending before the Learned Additional District Judge at Durgapur.
Lordship.
The Learned District Judge at Alipur. The petitioner claims to be residing at under police station Sonarpur.
Lordship.
Under police station Sonarpur in the district of 24 Parganas South. The petitioner further claims that she is working at Quest Mall, and for such reason it is very difficult for the petitioner to contest the proceeding before Durgapur court. The petitioner further claims that minor child is there.
No, my lord. No, my lord.
There is
a mention of a daughter.
For survival and of her daughter.
Lordship, it is from a previous marriage.
All right.
And there is no claim for her. No claim. No claim for the daughter.
All right. First up, the learned advocate appearing for the opposite party vehemently opposes the prayer for transfer. He submits that initially the petitioner filed a proceeding under the Domestic Violence Act before the learned
Baripur court.
Which court? Before the learned such and such at Baripur. First up,
Additional Chief Judicial Magistrate Baripur.
Before the learned Chief Judicial Magistrate at Baripur. First up, subsequently, the petitioner has filed a proceeding under section 125.
125.
Under section 125 of the Criminal Procedure Code before
The James, 10th JM Alipur.
For the learned Judicial Magistrate 10th Court at Alipur. First up, he submits that in order to harass the opposite party herein, the petitioner is instituting frivolous litigations before different forum. First up, however, taking into consideration the fact that a proceeding under section 125 of the Criminal Procedure Code is pending at Alipur, and the petitioner has to come to Alipur to contest the said proceeding. This court is of the considered view that taking into consideration the convenience of the wife, the matrimonial suit should be transferred from the court of the learned Additional District Judge at Durgapur to the learned District Judge at Alipur. First up, in view thereof, the matrimonial suit number 302 of 2023, which is presently pending before the learned Additional District Judge at Durgapur, shall stand transferred to the court of learned District Judge at Alipur, that learned District Judge 24 Parganas South at Alipur. First up, upon receipt of the records, the learned Additional District Judge at Durgapur is directed to transmit the records of the aforesaid matrimonial suit to the learned District Judge 24 Pargana South at Alipur immediately upon communication of this order. First up, upon receipt of the records of the aforesaid matrimonial suit, the learned District Judge shall assign the matrimonial suit to any of the additional district judge at Alipur.
Yes, my lord.
Full stop. What is the stage?
My lord, it is even before filing of written statement. It is in the
Filing
first
of
stage.
written statement, it will time other things. It will be.
I'm
Yeah,
grateful, my
disposed
lord.
of, yes.
I apologize again. My lord, I apologize.
Yes, next. Yes, call the Passover matter. Yes, Mr. Bordon, you have left. You have taken the brief also with you.
No, this is my brief.
No, your junior did not have the brief. I asked her to place the.
My clerk was there. My clerk was there along with the brief.
Your clerk ought to have given him the copy of the brief. I thought you have left. You have taken the brief along with you.
No, certainly not.
Yes.
My lord, the petitioner before your lordship, my lord, is a plaintiff in a suit for specific purpose of contract. Now, my lord, an ad interim order of injunction was passed. My lord, takes page 105.
Yes, what happened after that?
My lord, ad interim order of injunction was passed. Despite the order of injunction, my lord, property sold. Because there was injunction restraining from selling the property. Property sold. The ad interim order of injunction holds that I was in possession. Now, during pendency of the suit, I was dispossessed by the defendant putting a padlock. I file an application before the court below under 151 seeking restoration. That has been dismissed. Without inviting objections, nothing. Kindly seize the impugned order. The court holds that the interim order holds that I was in possession. The court holds that. Despite that,
Bordon, it is very difficult to implement an ad interim order of.
I appreciate, Mulot, but kindly seize.
It has to be a contested one.
But Mulot, kindly
Otherwise,
seize.
nobody knows. It's a finding only on the basis of your statement.
Police report called for. The police report shows on inquiry it was learned
Show me the ad interim order of injunction.
Mulot, the ad interim order of injunction, Mulot, is at page 105. Well, the relevant portion would be page 106. Having regards to the facts and circumstances.
106.
106, Mulot.
There is.
It is item number 30.
There is 2 volume of revision application. Why?
I don't know. At that point of time, the department was insisting that they filed in 2 different volumes.
Why?
Over 150 pages they were not taking.
Why have you made a revision application more than 150 pages?
All the pages, otherwise I would hold up for not disclosing adequate facts, suppression. Kindly seize, my lord. Having regard to the facts and circumstances appearing from the case record and also taking note of a submission such and such, I find this is a suit for performance of contract on the basis of an assignment executed by defendants favor of plaintiff, acknowledging fact defendants received 60 lakhs time to time from the plaintiff, which was initially the loan, subsequently converted into agreement for sale of the suit flats in favor of the plaintiff. It is further appears virtue of the assignment defendants agreed to make deed of conveyance respect of the suit flats in favor of the plaintiff and put the plaintiff into possession. Now the plaintiff apprehends defendants to bypass the payment of such and such, are trying to create third-party interest over the said flats. It also appears from the documents filed on behalf of the plaintiff that on 22/21 and 23/21, defendants received further 5 lakhs from plaintiff, thereby the term of the agreement extended. Further appears possession letters, plaintiff was put into possession. Therefore, if the apprehension of the plaintiff is materialized by the defendants, there will be a multiplicity of proceedings. In that view of the matter, the possession of the plaintiff in the suit flats are to be protected by an order of injunction. Therefore, considering the entire facts and circumstances as well as taking note of the documents filed before the court, I am of the view that the plaintiff has successfully made out a prima facie case to get an order of injunction, and that in view of the matter, I am of the opinion that if no order passed in favor of the plaintiff, at this stage, plaintiff will suffer.
Your possession has not been protected, Mr. Bordon.
Yes, despite that, Mulot. So,
despite that,
Mulot, I say
ultimate ordering portion does not
yes,
protect your possession.
So true, Mulot. But what I say, that I was in possession,
has been, my lord, held by this order.
Maybe, but in the operating part of the order,
Doesn't. What I say, my lord, if I am in settled possession, I cannot be dispossessed during the pendency of a suit. And if I am dispossessed, my lord, I am well within my right to take out an application under section 151 for restoration.
Mr. Bordon, on these facts, it may be very difficult. I can expedite the suit. Mr. Bordon,
kindly seize the impugned order.
Because even on the ad interim injunction, your protection has not been
Mullah,
protected.
kindly seize the police
Your
report.
possession has not been
Kindly
protected.
seize the police report. A police report was called for by the court.
Maybe, Mr. Bordon, but this order, which is the
sheet anchor of my case,
sheet anchor of your case, that also does not protect your possession.
What I say, my lord, is this. What I say, my lord, is this.
And Mr. Bordon, you are very well aware that mandatory injunction for restoration of possession
Rarest.
Yes.
I understand.
Rarest of rare cases, it
But
can be
there
passed.
should be an examination whether this falls within the rarest case. Kindly seize the impugned order. Lock, stock, barrel dismissed without even inviting affidavits.
Where is the impugned order?
My lord, kindly seize the impugned order is dated 2nd of December 2023.
No, where is that? Is in volume 1.
That is in, my lord, the volume
1.
Volume 1, yes.
Mr. Bordon, how can the documents be annexed after the impugned order? If it is an
No, it's volume 2, sorry.
No, it's
Yes,
in
my lord, the
volume
last.
1. It's in volume 1. My copy. So after the impugned order, the second volume comes with the documents. What is
page
the
1.
procedure, Mr. Bordon?
My lord, but nowadays, my lord, may I say this? We had never even heard of, my lord, civil revision applications being filed in 2 volumes.
That is for you.
My
You
lord,
have made a civil revision application for more than 150 pages.
Can't help
Has
it,
to
my
be.
lord, can't help. My lord, may I pose this question, my lord? Even we were not
Yes,
aware.
come to the impugned order.
My lord, kindly seize the impugned order, my lord. It starts. My lord, the facts are there, my lord. Kindly seize. This is the, my lord, the penultimate page of the impugned order.
Yes.
That's the operant portion.
Penultimate page.
Yes, of the impugned order, my lord.
Yes.
On perusal, it appears.
Yes.
On perusal, it appears to me that the suit for special forms of contract, permanent injunction with other reliefs. It appears ad interim injunction prayer allowed by this court. Defendant has not come and main injunction petition not heard. Police help prayer allowed, but no report came. Well, this is where I say, well, this is wrong. Because the police report was before the court. The police report was before the court and it was
also, Mr. Bordon, can an application for police help be passed without giving a notice upon the other
my
side?
lord, we have served if they don't appear, my lord. I have annexed all the orders, my lord. If they do not appear, my lord. My lord, kindly seize page 108 onwards. After, my lord, being favored with the ad interim order of injunction, my lord, I had complied.
Where is your 151 application?
151 application, my lord, is at page. Is, my lord, at page. This is, my lord, page 129.
One is second volume. Yes, 129 is second volume.
But relevant portions would be paragraph 8 onwards.
Yes.
Now, kindly see the police report. The impugned order holds the police report was not there. They put a padlock.
Where is the agreement for sale?
The agreement is not annexed. No, agreement is not annexed. Assignment agreement not annexed.
Was it a registered?
No.
What performance can you claim?
No, my lord. What I say, my lord, is not this. What I say, my lord, it's not a question of part performance. What I say, my lord, I was in possession. Albeit it might have been under the agreement,
Mr. Bordon, this is
subsequent
the
not
finding
registered.
Considering the order passed at the ad interim stage, this is the specific finding that whether you were in possession or not cannot be.
No, Manoj, that is not the finding in ad interim stage, Manoj. Kindly seize the ad interim order.
So,
Further
can it come to the
appears,
impugned order?
there's where
So,
the judge has
he
gone
had
wrong.
possession or not, it cannot be said at this stage.
Manoj, despite the early order of the court and despite the police report, the court.
Earlier order did not hold that.
Yes, held. I was in possession.
In the body of the
Yes.
order, but in the ordering portion,
No, it did
your
not,
possession
was
was
not protected. Yes, my lord. My possession was not protected. The fact remains the court held that I was in possession. And that apart, my lord, kindly sees the police report was called for.
Mr. Bordon, that is why it is always said, it is very difficult to implement an ad interim order of injunction.
Maybe I say this.
Body says something, ordering part
I
says
understand.
something.
I
How we will
still
execute
understand, my
that?
lord. Now this judge, my lord, calls for a police report and says that the police report
Where is the
not.
police report?
Kindly sees the police report.
You have not annexed that.
Police report holds that I was in possession and now someone else is in possession. And the learned judge holds that no police report came. Sees the date of the police report, my lord, 2022. It holds now someone else's possession. And despite that, the learned judge in the court below holds no police report.
This is on the basis of inquiry.
Yes, but kindly sees the impugned order, my lord. The
Who
order
were there?
proceeds.
Nobody knows who were there because you know in your presence this police help order was passed.
Yes.
They made an inquiry. Some persons were there. Upon local inquiry,
This was
purely on
no,
the
I don't say this.
I can deal with this.
I don't say this, but kindly sees the impugned order.
Purely on the basis of police report, it cannot be.
I don't.
said that you are
But what the judge says is police report had not come.
That may have been wrongly recorded because we do not know whether it was placed before the learned trial judge.
This is the order sheet, Mullah. This is the order sheet. Mullah, the copy I've handed over to you, Mullah, is the order sheet.
Yes, yes. This is.
Yes, my lord. It must be in the record for me to get a certified copy. So it was, and kindly sees the date, and kindly sees the date of the impugned order.
Defendants are out of India.
Yes, because they have sold in the meantime. Despite there being out of injunction, their property has been sold. And now when kindly sees, without praying for recovery possession, plaintiff files an application under section 151. Well, that's maintainable. Well, Lordship's court has held that.
What?
Well, dispossession during pendency of a suit permits me to file 151. What does the
though there is a provision under Order 39 Rule 2A, but does not stop you from yes. You can very well
maintain,
proceed, yes.
But kindly sees the impugned order. It says, but without praying for recovery possession, plaintiff files a petition under section 151. In the suit, plaintiff pray injunction status quo in past for transferring alienating third-party interest to hold constructive possession. So he admits possession. So he had physical possession or not cannot be said at this stage.
Where you are placing?
Well, the penultimate page of the impugned order.
Yes, penultimate page, which portion?
Well, the second paragraph.
Yes, the opposite party.
No, Mulot, it starts with the on perusal. It appears the penultimate page, Mulot.
Yes, yes.
It appears that the ad interim order prayer. Paragraph.
Yes.
There in the fourth line, he holds without praying for recovery possession, plaintiff files a petition under section 151, as if I am not entitled to it. And Mulot, most importantly, Mulot takes the fourth paragraph. What does the court hold? The opposite party made an application for temporary injunction. The learned judge passed an order of interim injunction restraining defendants from interfering with the possession of opposite party of the said room. Despite the interim injunction granted by the learned judge, defendants including
Ordon, this is not the finding of the judge.
This is the ratio of the judgment which will relies upon.
Yes.
So in spite of relying upon this, my lord, he goes on to say 151 is not maintainable.
That case was a different case.
But why should my 151 not be maintainable, my lord?
No, 151 may be maintainable.
Well, he is dismissed
but,
by
considering this fact, whether you are entitled to the relief on 151.
But that is for me to prove. That is for me to prove, my lord. And once this application is examined on merits, kindly sees, I find no reason to allow status quo ante as there are many cloudy things.
Mr. Bordon, this issue has to be decided by trial on evidence.
My lord, but kindly, my lord, kindly visualize this. There is an observation or a finding by a court saying that I am in possession. Thereafter, the court calls for a police report.
Alright, so you can serve, let it appear, because there is no scope to pass it in.
No, I want to let me serve and come. Because
difficult, because Mr. Bordon, it's better that the suit.
I appreciate, my lord, but premium cannot be given, my lord, for flouting orders of the court.
That is there, but the ad interim order does not clearly specify.
No,
so you may have a very difficult case on 151, though 151 may be maintained.
I appreciate that. But for that, the application has to be adjudicated merits. It cannot be dismissed, my lord.
By the order impugned, the application under section 151 of the Code of Civil Procedure filed by the petitioner herein, praying for restoration of status quo ante, ANTE, was rejected. First up, Mr. Bordon, learned advocate appearing for the petitioner, submits that the learned trial judge, while passing the ad interim order of injunction, specifically arrived at a finding that the petitioner was in possession of the suit flats. Of the suit flats. First up, he submits that the opposite party took forcible possession? Opposite parties?
No, that will be opposite party number 1 and 2 probably.
So opposite parties?
Opposite parties.
He further submits that the opposite party numbers 1 and 2 took forcible possession of the suit property by putting a padlock on the aforesaid suit flats. First up, the petition, this application is required to be heard in the presence of the opposite parties. Petitioner is directed to serve a copy of this application upon the opposite parties by speed post with acknowledgement due, and file an affidavit of service on the next date. First up, list this matter under the heading contested application in the monthly list of. This is not a motion matter. Contested application in the monthly list of April 2025.
March, at least March.
March 2025. Yes. Next.
$32 million I appear
I'm
for the defendant.
Opposite party caveator.
A defendants in a suit for eviction under Presidency Act. Admittedly, my lord, the suit was filed by the life interest holder. My lord, the life interest holder filed the suit.
What is the impugned order?
My lord, the impugned order, my lord, is an order by which, my lord, the husband of the, my lord, the present plaintiff, the transposed plaintiff, who was the legatee under the will, has been permitted to depose on behalf of the plaintiff.
No, I could not follow.
My lord, the husband of the plaintiff has been permitted to depose on behalf of the plaintiff. On behalf
of the plaintiff?
Not as a witness cited by the plaintiff, but on behalf of the plaintiff, saying that she is not mentally and physically stable to withstand examination. Kindly seize the order. My lord, this application, my lord.
Mr. Bordon, take back that police report in the earlier matter. It is
an earlier order might be material, my lord. That order is an order dated 16th of November 2022 at page 75. What happened, my lord? Since the life interest holder, my lord, filed the suit, during pendency of the suit, my lord, life interest holder died. My lord, the beneficiary or the legatee under the will was arraigned as the pro forma defendant.
Now, they were transposed.
It was transposed. Now, this transposition order is at page 75.
Yes.
Kindly sees the operative portion of the order, my lord, at page 77. They filed an application under Order 1, Rule 10.
Yes.
Kindly sees, my lord, page 77. It is contended by the defendant that Order 1, Rule 10(2) CPC is not an applicable in this case. It is not material what section of provision has been quoted in the application. It is to be seen only about the contents of the application. So the prayer for the petitioner is hereby allowed. Let the petitioner, pro forma defendant, be transposed into the category of the plaintiff since deceased. Now, my lord, challenging this order, an earlier civil revision application was filed, which is pending adjudication. That is pending adjudication, the propriety of this order.
So, according to you, this order could not have been passed.
I say.
Why?
No, I'll address that at a later point of time. On a later point of time. But my lord, what is most important, my lord, now an application comes at page 131.
That application is to be heard along with this, Mr. Bordon. Because otherwise,
my lord, even if that order stands.
No. Because that might have some bearing.
It has a bearing.
So then that CO has
That's
to
23. That's 23. I have to seek assignment then.
I'm releasing the get it assigned.
No. Or I say, my lord, even if that order stands, my lord, this impugned order cannot stand. Kindly sees the, my lord, the application, my lord.
Yes.
Application under section 151 at page 131. In terms of the observation made video order dated 109 of this learned court, your petitioner has tendered evidence. Now, my lord, who is the petitioner, my lord? Is Joyashree Kaur, the transposed plaintiff.
Joyashree Kaur
is the transposed plaintiff, my lord.
Because that order has been given effect to.
Given effect to? Yes. In terms of the observation made video order dated such and such, your petitioner has tendered evidence today through her husband, since he is competent to tender evidence on her behalf as per provision contained in section 120 of the Evidence Act. Most of the husband of the petitioner is fully conversant with the entire facts and circumstances of the case.
What is the suit for? What is
Recovery
the ground?
possession. Recovery possession.
Premises Tenancy Act.
Yes, reasonable requirement.
So the
Kindly-
husband cannot depose on behalf of the wife.
No, kindly sees. It takes the application further, my lord. Your petitioner states that she is aged about 64 years. She is suffering from various ailments and she becomes frequently unconscious because of her ailments. She is under constant treatment. The petitioner states she is not in a position to face the stress of examination and cross-examination in connection with litigation. She has lost her ability to remember even the day-to-day incident. Then, my lord, your petitioner submits learned court cannot direct any particular person to be cited as witness unless situations do arise. Then, my lord, kindly sees paragraph 7. Your petitioner states that there's evidence recorded at the time of cross-examination of DW1 justifying and proving the relationship landlord-tenant. Then, however, in view of the direction of this learned court, your petitioner has agreed to tender further evidence to her husband, who has been authorized by the statute to depose on her behalf. But now kindly visualizes. This husband is Amit Kaur. It's not as if, my lord, he is being cited as a witness on behalf of the petitioner or the plaintiff, my lord. It is, my lord, he is deposing on behalf of the petitioner, my lord. As if to say, whatever.
Has he deposed?
No, not as yet. But he was deposing as the DW1 in PW1 initially.
PW1. Yes.
He was deposing as the PW1 initially.
Yes.
He was deposing?
Yes.
Yes.
He was deposing. What happened, my lord? Now, Shefali was the mother, the life interest holder.
On behalf of the mother, son was deposing?
Yes.
Yes.
Not on behalf. He was cited as a witness on behalf of the plaintiff.
Yes.
Cited as a witness,
Yes.
independent witness. Now, my lord, what happens is, under the garb of this order of, my lord, 16th of November, my lord, the petition, the present plaintiff files an application saying the court has permitted.
No, the mother of Amit Kaur was the life interest holder.
She filed a suit. She died.
Passed away.
He passed.
So the
She
legatee.
filed a suit. She passed away. There is a will.
There's a will.
So, as per the will, who are the legatees?
The legatee is the initial pro forma defendant who has now been transposed as the plaintiff.
Joyashree Kaur.
Yes.
Joyashree Kaur.
Joyashree Kaur is the daughter-in-law.
Daughter-in-law of Shefali.
Daughter-in-law.
And the
So,
wife of.
daughter-in-law has been now transposed to the category of plaintiff.
Yes.
So her husband is deposing, who was initially cited as a witness on
behalf of the mother.
while
As PW1.
as PW1 when his mother was the plaintiff.
Yes. So he was the PW1.
Yes.
Now the issue today is, my lord, can he depose on behalf of or my lord, for?
Depose as continue to depose as PW1.
Kindly cease.
Continues to depose as
No, my lord.
PW1.
That is not the issue, but kindly cease the application. The application is that in terms of the order of that court, the earlier order which I placed, the plaintiff has been permitted to adduce evidence. Does that order even say that, my lord? May I pose the question to myself? Kindly seize the earlier order, my lord.
Which
Seize
order?
the earlier order, my lord.
Earlier
At
order.
Page 75. The
Yes.
operative portion is, my lord, it is contended by defendant, order 1, rule 10 is not applicable. It is not material such and such.
That is the operative part.
Operative part is,
Yes, that you have placed.
So, my lord, does this operative part give, my lord, the plaintiff the liberty to prefer the present application? Because this application is premised on this order.
Transposed to the category of plaintiff, that means she now has a right to depose.
She now has a right to depose. Now,
Yes.
if she has to prove her case, either she might appear personally and depose, or else someone else will depose as an independent witness on her behalf. But that husband cannot come and depose on her behalf.
That,
Well,
Mr.
there- well,
Bhatt,
there's
that
distinction.
can be clarified.
Well, there's
How that
distinction.
will be.
But why I say, well, Fakir, kindly seize now the evidence which the husband wants to, my lord, give before the court.
This is the chief which has been filed.
Yes, further examination in chief. Now, my lord, my question today is, if it's a further examination in chief, this is not the procedure, my lord, to be adopted. And he is deposing on. Has to be recalled. If, my lord, he continues to depose as PW1, he has to be recalled.
Yes, you can.
If he wants to continue deposing as PW1, he
Yes.
has to be recalled.
Why?
Why? Because even the DW1 is complete.
So
PW.
this is the further evidence.
Yes. And now what he.
The completion of the defendant's
Yes.
Argument, my lord. Yes, right.
So then it has to be recalled.
It has to be recalled. So then, my lord, Amit Kaur, who was deposing as PW1, will continue to depose as PW1.
Yes.
Not on behalf of his wife. Well, there's a subtle difference, my lord. One is, my lord,
Show me the application once.
well, the application is at page, my lord, 131. Kindly see page 132, first paragraph. In terms of the observation made video order dated 109, your petitioner has tendered evidence today.
Mr.
Your husband.
President, at one point of time, the mother died. After the evidence of PW1,
DW1, my lord.
after DW1,
My lord, at the stage of argument,
Yes.
the matter was under the stage of the argument. And my lord, if your lordship goes to
So-
the order.
evidence was concluded
Yes.
of the parties.
Yes.
So there was no necessity for the plaintiffs to adduce any further evidence.
Yes.
Unless it's a case of recalling of.
Yes.
Because what the plaintiff says is, by virtue of the earlier order, she is being forced to give evidence. Kindly seize.
Not forced to.
No, she's agreed to give evidence. Kindly seize paragraph 8 at page 133. What is the pleading? However, in view of the direction of this learned court, your petitioner has agreed to tender further evidence through her husband. So, my lord, now the evidence is as if, my lord, now the PW2 would be.
So in view of the direction, there is no direction
There's
of
no
the
direction
learned
below.
court below.
Yes, my lord. This is the point of adjudication, my lord. Where is the direction if I'm.
Show me the impugned order.
My lord, the impugned order, my lord, is at, my lord, 2/12/2024, my lord.
Yes.
The certified copy is annexed. My lord, see, the relevant portion would be, my lord, the last paragraph of the first page, my lord, of the impugned order. First of all, it shall be mentioned that the order number 109 dated such and such, this court observed that the facts that on the consent of original plaintiff Joyashree Kaur collected rent from the defendants and after death of the original plaintiff Joyashree Kaur become landlord owner of the suit premises on the strength of probated will executed by Khetra Mohan Kaur, set can be to be established by adducing evidence for the petitioner, Joyashree Kaur. Evidence which requires to be adduced as per Order 109 is on the point of acquiring right by Joyashree Kaur over the suit premises, not on the point of reasonable requirement. The evidence is already completed in this suit and is on the verge of disposal as the matter was fixed for argument before the defendant raised the jurisdictional issue. It is the suit of the plaintiff and the plaintiff is the dominus litis. Previously, when the original plaintiff...
Only one thing, Mr. Bordhon, the aspect of ownership has to be proved.
By whom?
Has to be proved because that was a stage when the life interest holder was deposing. So in view of the subsequent event, since the life interest holder has passed away, so the question would be whether the present plaintiffs has become the owner or not, or has a right to get this. So recalling or the further evidence may have to be given.
May have to be given, my lord, but the issue today
may have to be given.
But the issue today is, my lord, whether Amit Kaur can depose on behalf of the plaintiff under Section 120 of the Evidence Act and in terms of the early order. That is the issue, my lord. My lord, he can continue as a witness or he can be cited as another witness, but he cannot depose on behalf of his. Just like, my lord, I should be deposing, I give a power of attorney to my learned junior friend, and he, my lord, and she, my lord, appears before the court. Whether that is permissible in this case. Whether that is permissible, my lord. That is the issue which falls for consideration. My lord.
You have relied some judge decision before the land court below.
No. That was
cited
before the judge in the court below, my lord. I will not rely upon that.
You are not relying upon that.
Yes.
That's not a separate issue altogether.
You have a copy of the Evidence Act.
Evidence Act?
Yes.
Yes.
Because you have relied upon Section 120 of the Evidence Act.
They have relied.
We have relied.
They have relied.
That's Evidence Act.
But 120 is on a separate footing altogether. The husband is supposed to know and may be a witness.
Yes, testify.
But he cannot testify on behalf of the wife. Being a competent witness is one thing, and deposing on someone else's behalf is something else.
So according to you, Amit Kaur could be a competent witness.
Might have been. But that was not the issue which fell for consideration in this application. That was not an issue which fell for consideration in this application. The issue which fell for this for consideration in this application was whether Amit Kaur could depose on behalf of his wife under letter of authority. Because that is the evidence. Kindly sees. He says that he is deposing on the strength of a letter of authority at page 2 of this further examination. Authorized me to adduce evidence on her behalf. How can that be permissible? Everything will be hearsay. Everything will be hearsay.
You have concluded.
More or less.
You want to submit something tomorrow?
Tomorrow one keeps on Friday morning. Friday morning.
My lord,
You have difficulty.
Let us fix before court number 26. Today and tomorrow. Friday would be...
entire day?
I don't know how long it will go. 26 is a very difficult court.
Friday.
Friday.
Mr. Bordhon, learned advocate, appealing for the petitioner.
Then in that case, make it on Thursday because Friday I have two matters fixed in two different courts, my lord.
Yes, Mr. Bordhon.
I'll just
yeah.
No, if it's Thursday 10:30 in the morning, it's fine. I'll be able to address.
Not 10:30. Motions
that
are
will be a
to be
problem. That will be a problem.
first time motions.
I understand. Then
at
21st.
At 2
21st. That's Friday.
First I have
because
come.
Tomorrow and day after both.
The first hours Friday. Returnable matters. Further hearing. Mr. Bordhon, learned advocate, for the petitioner commences his argument but could not conclude due to paucity of time. Mr. Bliss, as prayed for by Mr. Bordhon,
as jointly paid for by the learned advocates for the parties.
Well, Friday, it will be difficult for me, I think. Because
Friday, it will be difficult.
matters fixed in two different courts. That is the main thing. One at
Then, Mr. Bordon,
24th.
24th at 2 p.m.
24 কি অবস্থা কিছু নেই তো list this matter on 24th of March 2024 under the heading.
I'll try to lay my hands on any judgment because this is not.
Sorry, February. February for further hearing. Okay.
Right, your lord.
You have an extra copy of this. I'm keeping it.
Yes,
Right.
I don't know.
Not 2 p.m. further hearing where it is taken up.
I'm grateful.
No fixing of time.
Right. Right, your lordship rising may be permitted to mention item 49 of your lordship's list. Lordship,
49,
there is
yes.
some urgency. We had filed this application against an order which had called for an attachment of a certain sum in the bank account. Now,
Yes.
thereafter, there has been a subsequent order directing the bank to disburse that sum. So, if some precedence could be granted, it's item 49 before your lordship today.
So,
If it could be
after
taken
the-
up tomorrow
after
or
the
the
new
day after.
motions, only I think 10, 11 matters are above you.
Yes, your lordship. If some precedence could be granted, your lordship, tomorrow or the day after, Mr. Devnath Ghosh is leading me. He shall be addressing your lordship.
Who is leading you?
Mr. Devnath Ghosh is leading me. He shall be addressing your lordship.
Tomorrow or day
Tomorrow or
after?
day after, as
I
per your
think it
lordship's
may reach
convenience.
within the day after tomorrow.
Well, insofar as item 33 is concerned, the next matter after this, my lord, tomorrow I'm indisposed, your lordship, due to certain medical exigencies. So if an accommodation is prayed for on my behalf, I will kindly accommodate.
Lordship, may I be permitted?
I'm for the petitioner in that 33 what my learned friend has prayed, I don't know.
এটা কি এরা দিল নাকি না আমাদেরই বই?
Lordship, may I be permitted to mention?
So in this 33, what my learned friend has submitted in this matter, I'm for the petitioner. What have you said?
I'm for the OP. What I said, I'm for the.
He said he will be praying for an accommodation tomorrow.
I did not say that the matter will not be taken up. I said I'm appearing for the opposite party, and if any accommodation is prayed for, let it be accommodated for tomorrow.
For tomorrow.
For
Then
tomorrow.
let it be fixed on Thursday, my lord.
I don't have any.
Let it fixed.
All right, tomorrow you are here. Ask some of your friends to.
Lordship, may I be permitted to mention one matter, item number 141 of today's list. Lordship, that matter between the same parties, another matter, a section 24 application for transfer of the suit is pending. Lordship, this court, honorable court has the determination of section 24. Lordship, may both the matters be taken up together.
Where is that matter?
Lordship, that matter is not listed. 149 and another civil 149 of today's list.
দোলন মন্ডল দেবাশিস সরকার।
Lordship, yes, Lordship. They have another matter pending before this honorable court, that is section 24. Lordship,
It's also section 24.
no, Lordship, this is for an ex parte order, vacating of an ex parte order.
So mention at the time, I do not know who is appearing for the petitioner in that matter.
Petitioner, we are the same petitioner, Lordship. We are for the petitioner.
You have filed that application also has.
That is from 2021. The other CO, the section
2021, I do not have determination.
Lordship, section
2021, I do.
My lord, this 33, item 33, my lord, my learned friend also saying that he will not be here. But let it be fixed in Thursday, my lord. Because
Let
there
it
is
not be
urgency,
long.
because this is related to water connections. But I have also.
Then let it appear tomorrow. Then